My lord, may I permitted to mention a matter? Earlier occasion, I also mentioned your lordship was pleased to direct me to mention the matter in the first working day of the month. Urgency is this, my lord.
What do you want? Inclusion?
No, my lord. The
You want
son and
inclusion?
daughter-in-law. Hearing, because, my lord, the petitioner is physically and mentally harassed by his son.
Oh, what you want? You want upgradation?
Upgradation and early hearing of the matter.
Early hearing is all right. Upgradation?
Upgradation and early hearing of the matter.
Upgradation.
What is the item number?
Item number, my lord,
1105
of 2025.
1105 upgrade.
May I get your lordship kind leave, lordship, to move on very urgent tender matter, lordship. What happened? The work order has been issued without tender.
Without tender?
Without tender, in violation of the finance rules, lordship. Finance rules suggest that if the tender value is 1 lakh and above,
Holding the auction?
lordship, CMOH diamond, so not to be so.
All right. Health.
Lordship, the new incumbent take charge on 8th. Without issuing tender, he has already given work order. Lordship, kindly take up tomorrow or day after tomorrow, any day, lordship.
Day after tomorrow, serve notice.
Lordship, I shall serve.
Lordship, my lord, may I permit to mention, for upgradation, my lord.
Item number?
Item number 725.
725, yes.
There is online, my lord.
Lordship, may I be permitted?
Don't hand over the slip. Only the
Lordship,
number will be served.
Another urgent motion, my lord. 88, my lord, daily list, my lord.
Daily list, it's already there. Please don't mention.
Lordship, 3 matters for upgradation. Lordship, 3 electricity matters. All are urgent.
The numbers?
Lordship, item number 425, 376, and 417.
400?
417, the last
417.
417. And Lordship, another matter for contempt application.
Inclusion?
Inclusion.
Hand over the slip.
My lord, Mr. Devarpur is online, my lord.
Your ladyship's kind leave, my lord. I had mentioned this matter at 2 p.m. on Friday. My lord had directed me, my lord, to mention it today again, my lord. It pertains to that petrol pump dealership, my lord, where the district magistrate of Burdwan, my lord, has held back, my lord, the no
Where
objection.
is the matter?
My lord, it's item number 53, my lord. My lord had
Daily
said
list?
that daily list. My lord had said that you mentioned the matter. You
Upgraded. 53. Don't hand over the slip. 53 of the daily list to be upgraded on Friday. Serve notice.
Yes, my lord, I'm mentioning about notice also. I'll again serve notice.
Don't give the slip.
Very
Well, lord, I was praying for
Not from there.
Like
Yes.
inclusion, my lord. Inclusion, my lord.
Hand over the slip.
Lordship, another matter.
No further.
I am mentioning a matter of contempt application, my lord.
For what?
A contempt application.
For what?
Inclusion, madam.
Hand over the slip.
My lord,
Yes.
Mr. Devarpur is online, my lord. Circumstance matter.
Online, I'll take up. Yes. Inclusion, hand over the slips, please.
My lord, may I mention?
my lord, 1
1 minute.
My lord, may
Pass on the slip from behind.
Lordship.
Yes.
surfacing matter for restoration, my lord.
What do you want?
Restoration.
What do you want?
Inclusion.
Hand over the slip.
For item number 1495, the bank authority has frozen my account without any notice, Lordship. Only one item. Lordship.
Let it remain frozen. Wait.
For upgradation, your lordship.
Which item?
2324.
2324. All right.
With my lords, kindly may I be permitted to mention for upgradation item number 142, my lord.
Daily list.
Yes, my lord.
Why you want upgradation?
A transformer has been installed over my private land, my lord, without taking my permission. I'm not in a position to utilize my land, my lord.
Item number, daily list?
142, my lord.
142.
My lord.
Janababu, dekhchen to?
Deeply obliged, my lord.
my lord, I will inclusion, but my lord, only with a prayer that my lord may it appear on the 12th of February. Lordship has fixed a connected matter on the 12th of February.
Put it in the list on 12th.
I'm very grateful.
But I'm
And
praying
is
for
the
upgradation.
connected matter number mentioned over there?
Yes, ma'am. I shall, my lord, give it to you. I've handed it up. It's now given.
I am praying for upgradation, item 348
Of
of the monthly list, of the daily list. There's extreme urgency. The bank has declared me fraud despite giving me notice for hearing and intimating that no hearing will take place on that day. And
go. I've taken down the number.
May I permit to mention that one leave may I say this urgent presentation what happened I was running a shop there is a Form 1 license issued by the competent authority. Thereafter, for upgradation, I applied for upgradation of new machinery and new further license. Upon inspection, that was being granted. I obtained loan machinery installed. Now, all of a sudden, they have said that you are an aspiring candidate who has applied for. They have not even considered that my application has already granted. I have installed machinery after inspection. They have cancelled that. They have said that
Cancel the upgradation.
Upgradation is.
But the otherwise, your license is.
Until and unless I uninstall all this machinery, they will cancel my license. Entire license Form 1.
Who? Which authority?
Not the appropriate, not the authorized officer of the forest department.
Forest.
But I will not serve notice, not anytime, not in the next week, not in
Next week. Tuesday.
May I have my lord's leave?
Please.
Lordship, may I have my lord's leave, my lord, to mention a matter? Lordship, this matter was mentioned by my leader, Mr. Abhijit Mitra, last week. Lordship had observed that if the matter is not taken up by last week to mention today, my lord, he's appearing online if Lordship can.
Please wait, I'll finish up the physical mentioning. What you want?
Upgradation, my lord.
Give me the number.
Item number 1499 of combined list, my lord.
1499. All right. Upgraded bundle. Don't hand over the slip.
Item number 275.
For what?
Matter is surfacing matter. Let this matter be appear appropriate heading. Surfacing.
The heading is very important.
No.
Then?
Then let this matter be upgraded. 275. 275.
275 which list?
Today's list.
Daily list. Where you want to be upgraded? Where?
Kindly take it. 275.
সারফেসের কোনো হেডিং আছে আমাদের? জানাবো সারফেসের হেডিং আছে আলাদা? কোথা থেকে শুরু হচ্ছে? It is
My lord.
আচ্ছা 275 টাকা সারফেসে দিয়ে দেবেন তো আদার দেন ইলেকট্রিসিটি আছে ওটাতে দিয়ে দেবেন put it under the surface bundle 275 278 of the monthly list surface দিয়ে দেবেন তো
319 of today's list, my lord. If that could be upgraded, this.
Where is it a surface matter?
No, this is not a surface.
Then?
The normal matter, bank has classified me as a fraud without giving me a hearing contrary to the RBI master circular. Now the police authorities.
Which item?
319 of today's list.
319.
Yes.
Upgrade it.
Very
file out a daily list.
Upgrade.
My lord, for upgradation, lordship. 924 of the monthly combined.
924. My lord, I'm praying for upgradation.
Kindly, may I seek your ladyship's kind leave to mention a matter? This is again for upgradation, item number 349. Your ladyship will just allow me to canvass my urgent.
349 for what?
This daily list.
Don't canvass. 349.
Ladyship, if I may.
1495 kindly, lordship, they are not running the brightness, lordship, due to the freezing of the
item 49.
1495 of the monthly list.
1495.
Upgradation, lordship.
You mentioned so many matters.
Lordship, this is not electricity matter. The bank account has been.
So what? 1495. Very well.
Ladyship, if I may be permitted to mention, ladyship, item number 321 of today's daily list, ladyship, have been classified fraud in contravention to the guidelines of the RBI. Ladyship, if the matter may be upgraded later.
Where to upgrade? Try to understand. The list will not be called if upgradation goes on in this matter.
Ladyship, 321, ladyship. Kindly, ladyship.
321, upgrade.
May I have your lordship's leave?
Item number 330 and 332 of the today's list, my lord. Praying for upgradation. Why, my lord?
No, don't say why.
330 and 332 of today's list, my lord.
Very well.
Praying for upgradation.
Very well. 304. Very well, go.
Lordship, may I have your lordship's leave to mention item number 79 of the day's list, lordship. This matter had been taken up on the 15th, lordship. Thereafter, your lordship had directed the matter to appear in the list. It is there, but it is not being taken up. Lordship,
What can be done? All
Lordship,
matters are of the same
this
type.
is a matter of a medical practitioner who is suffering, who has been
It is
suspended.
the matter of same type. All matters are same.
Lordship,
If you
will
go on
kindly,
mentioning,
Lordship,
it
will
cannot be helped.
kindly allow, Lordship, because
It cannot be helped.
whole
Yes.
week has gone, Lordship.
171 of the monthly list. I'm paying for upgradation, Your Lordship.
1771.
Yes.
All right.
Lordship will kindly hear 79, Lordship, because that is a very urgent matter.
1771. I don't know. 196. Very. The list will go up and down, and no matter will be taken up.
Lordship, five matter, WPA 1.
5 matter for what?
Lordship, bracketing the application.
Sorry. Well, yes.
Mr. There was under my lord.
All right, if somebody is online, I'll take up.
Circuit bench matter, my lord.
Please wait. Yes.
To mention item number 1477 of the combined list.
For what?
Relating to the eviction of unauthorized occupant tax due to want to elimination this particular list.
Which one?
1477.
1477 released. Today, give your name. Order will be recorded. 1477. Release for want of determination. Yes.
Direction was given to file the appeal position and reply. Liberty to mention was there. Original side matter, hearing matter.
It has the affidavit has not been filed.
No meaning.
Give the number. To be mentioned, it will appear and serve notice upon the other side.
I will serve in the matter kindly for hearing. I will serve the notice upon.
No, not for hearing. I'll put it under the heading to be mentioned for filing the affidavit in opposition, extension of time or whatever. Let us see.
Twice they have taken the time.
Very well, then I'll fix it up for hearing. Let it appear as to be mentioned. Serve notice.
Item number 1460. My lord, there is an extreme urgency in this matter.
Daily list, combined list 1460. Don't hand over slip.
Very well.
My lord,
Yes.
item 1838 of the monthly list.
1838
of the monthly list. I'm praying for upgradation.
Very well. Serve notice. No slips.
I am praying for upgradation, my lord. I am praying for upgradation
Please do not hand over the slip.
I am praying for upgradation from the monthly combined.
Item number.
Item number 1948.
1948.
2109.
How many?
3. Out of 17, I am 3 only.
Out of 17.
Out of 17. 1948, 2109, and 1658.
Very well. Go. 1 minute, yes.
I'm praying for upgradation. Item number 1543 of the combined monthly list.
Serve notice.
My lord, at the 64, it was appearing as an urgent motion under the heading urgent motion, my lord, and it was appeared on 29th January. Your lordship directed to take up the matter on 5th, my lord, today. It was under the heading adjourned motion, my lord, though it is direction of affidavit was last letter.
So it is already there. Why are you mentioning?
It was under the heading urgent motion.
All along it will remain under the heading urgent.
My lord, there is a victim lady, my lord, who is about to be treated under the Mental Health Care Act 2000.
Please wait. Yes.
Item number 1550.
For what are you mentioning? Item
1550.
1550. Yes.
May I be permitted to mention a matter? My lord, it is for the upgradation.
Number.
Item number 95 of the daily list.
From daily list, you want upgradation. Where to upgrade?
My lord, the respondent authority opened a
Whatever is the matter, but where to upgrade? There is no other place.
My lord, and kindly fix the matter tomorrow.
Oh, sorry, madam. 90.
Yes, ma'am.
It's already at the top. Cannot be helped.
I was once again mentioning.
Please do not.
Lordship, it's going down from 40 to 79.
427. 427.
1427.
Oh, 1427. Upgradation. Very well. Serve notice. Yes.
Lord, may I mention, Lord, an original side matter?
Yes.
I want to move, Lord, after court application, Lord, dead body is not handing over to the Lord, execute.
Who is not handing over?
Police, Lord, it was
police.
Yes, Lord.
For what reason?
What happened, Lord?
Where is the location?
Sampugul police station.
Cause of action, Shampukur police station.
What happened, Lord? They are asking.
No, don't say. When did when
Brothers, Milord, there is a litigation between the brothers and Milord disease. Milord, that's why Milord, brothers are not coming. Only one brother. Brothers are not coming. Police is saying no, I will not hand over the body unless brothers are giving consent.
When did the death take place?
Milord, death took place Milord Saturday. Milord,
Where is the body in the morgue?
The morgue is it is in the morgue.
A Hindu.
Hindu.
Very well, give. Then it has to be moved. How will you serve notice?
Milord, I will serve, if your lordship give me leave, Milord, at 4 p.m. or 4:15, Milord, I will serve notice, Milord. It is ready, Milord. I will just stamp and it is ready.
Well, will prior to rising come at 4 o'clock?
Sorry, yeah.
And serve the AOR's office.
Yes.
This will be important.
It's a writ petition at the instance of Kerala government, Milord. Writ petition at the instance of Kerala government, Milord, challenging Milord, the MSME proceedings, Milord. In that writ,
Kerala government?
yes, Milord. Challenging MSME proceedings, Milord, is being held here, Milord.
The
Now, Milord,
proceeding is held here.
yes.
And the order is of the Kerala government.
Yes, Milord.
I
The
cannot
contract
follow.
with Milord, Kerala government.
Oh, you have a contract with the Kerala government. Yes.
I am representing the writ petition is at the instance of the Kerala government, Milord.
All right.
Now, Milord, challenging that MSME proceedings, Milord.
All right.
Now, Milord, in that petition, Milord, there was an order of stay, Milord.
Yes.
Now, Milord, that has expired, Milord. I have prayed for Milord, applicant taken out application for restoration of
Extension.
interim order. Now, Milord, in the meantime, they have given certain opportunities for settle the matter, Milord. It may be settled, Milord. If you kindly fix it any day, Milord, in the next week, Milord.
Why? If you can settle it out
Milord,
of court, why you want a court's order?
That, Milord, we have to, Milord, offer, Milord, to the land advocate representing the other party, Milord. That communication is required, Milord.
So you communicate. Who is stopping you?
Milord, possibly, Milord, they are requiring to sitting with the advocates, Milord. Nobody is representing in this court, Milord, as yet, Milord. If they appears, Milord, we can go for settlement if possible, Milord.
MSME?
Yes, Milord.
MSME, nobody is appearing.
No, not MSME. On behalf of MSME, Mr. Shamrat is appearing.
Yes,
But
somebody
so far
was.
the company is concerned, nobody.
And then how can the court bind the company and bring him over?
No, certainly. If they appears only then, otherwise, Milord, my interim order has to be restored, Milord.
Yes.
No, kindly then fixes it.
But then, your contract will be with the MSME authority.
Yes. No, my contract with the company.
Then why are you coming? You bring the MSME through
They
here.
have filed a MSME proceedings here in Kolkata. So the
I
jurisdiction is.
understand I am not.
The jurisdiction is before the Kolkata High Court
the jurisdiction point.
Because Milord, MSME tribunal is in Kolkata. The company is in Kolkata. Against whom, Milord, I have filed the writ petition.
Try to get it done out of court. You want the matter to be put in the list as to be mentioned or something?
We mentioned, Milord, kindly any day, Milord, as per your convenience.
Where is what is the number?
Milord, yes, Milord.
Then next week, serve notice. 12th it will appear. Next Wednesday. To be mentioned, serve notice upon all the parties.
May I
Yes,
trouble your
please.
lordship with Milord item number 109. Milord, I
Daily
may not
list.
daily list. Milord, I may not be in a position to wait till tomorrow. Well, the difficulty, Milord, may I just indicate? Milord, I was the highest bidder for Milord purchasing something, Milord, in auction. Milord, the time to make the payment was yet to expire. They cancelled, Milord, the entire tender. Milord floated a new tender. Milord, this was taken up by your lordship, Milord, on 21st of January. The tendering authority was absent. Despite Milord notice, we have Milord put them again, Milord, on notice. Matter was made returnable on 29th of January. Milord, if they Milord sell Milord to a third party, despite I being Milord the highest bidder, Milord nothing will
But then
remain.
you said the tender has been cancelled.
Milord could not have been cancelled because Milord the time was yet to expire for me Milord to put in the money.
But then if the authority cancels a tender
Milord, there
process.
is no right Milord vested in them Milord to cancel the tender without showing any cause.
No, absolutely
Milord,
no.
I will satisfy your lord. My
I
lord was
don't
also
think.
satisfied, Milord, on the last occasion. If I have, Milord, understood my lord's mind, Milord, correctly. Milord, this was taken up. Tendering authority was not there, which is why, Milord, the matter was. Milord, I have annexed the order also. Kindly just have a look at, Milord, 3-line order, Milord, passed by your lordship on the last.
3 lines order. Just say what is there.
Milord, it says, the bid inviting authority, MSTC Limited, is not represented. Let further notice be issued. List the matter on 29 January. Learned Council.
MSTC over here is?
Milord, metal scrap tendering.
Who appears?
MSTC.
MSTC, somebody appeared on the last occasion. I cannot recollect.
Milord, I know someone. Milord, I am forgetting his name. Milord, I'll try and contact him. Milord, maybe Milord come back tomorrow, Milord, with this item number 109.
But then they have not opened the tender.
On the last occasion, WBACDCL, whose product are being sold through MSTC, the tendering authority, they said there is a fresh tender that has already taken place.
Very well. Tomorrow you give the number.
So grateful,
And get hold of the learned advocate.
I'll try. I am
Somebody
forgetting his
appears
name.
over
My
here.
memory is betraying me. I will try.
To be mentioned tomorrow.
So grateful.
For upgradation, my lord, item number 1277 and 1609, lordship, of monthly list. 1277 and 1609, lordship. I will serve notice, lordship.
Yes, obviously.
Grateful.
Item number 311 and 313.
Daily list, it cannot be upgraded.
Very urgent, my lord, the additional time for registration of the property, my lord, this was already been done. Process was already been done in 2014. Only some deficit copies was there. Now the stamp authority is saying that the property has to be re-evaluated at the market value.
How many days in between?
6 years have passed, my lord.
6 years? Sorry, I'm not entertaining. Yes.
My lord.
Sorry.
My lord, may I permit to mention for upgradation? Monthly is 7 to 8.
7 to 8?
Yes, my lord.
Very well.
My lord, may I permit to mention, my lord, what for upgradation from monthly list, my lord? My item number, my lord, 1474, my lord.
Why?
My lord, that is a my lord, IVF proceedings. Here, my petitioner's age is, my lord, about 60 years, my lord. So
Petitioner is a male or a female?
Petitioner is a male, but that is the IVF proceedings, so that if the permission is not granted, my lord, there is a delay, my lord. So
the 60 years he has crossed. Sorry, I cannot take up. Yes, online mentioning, please.
Lordship, may I leave to mention one extreme urgent matter? It is the circuit bench Jalpaiguri matter. Against the petitioner, Lordship, a parallel proceeding has been initiated by the authority on the same self-issue and prepared an adverse report, and I apprehend any coercive steps against me.
No, but
So,
then
Lordship,
the circuit bench will be function. Is it not?
no, on Monday, Lordship. I can't wait, Lordship.
You can certainly wait. I am not satisfied with the urgency that you have pleaded. Please take steps before the circuit bench. Yes, Mr. Mitra, were you mentioning something?
My lord, that matter, the Jute Association, Lordship, it is Friday's Lordship said we'll be taking up applications. Last Friday, we were hopeful it will be called on because it will become infrastructure. This is really a public where the sugar industry is not complying with the order. The Jute Commissioner's report is in our favor. I'm not taking any exception. I should only seek implementation. If this coming Friday, if this gets some upgradation, my juniors there.
Where is the number?
My lord, it is item 77 in Lordship's list.
Daily list. 77. Upgrade it on Friday, 77.
I'm
all
very
right.
grateful.
Grateful, Lordship.
Mr. Chatterjee, yes.
My lord, may I leave to mention one urgent matter to move this application by tomorrow that the ADM Malda who has passed the order to stop the business of my nursing home, that is beyond his authority. Only the Department of Health that can pass. And this is the second round of litigation. I have come up earlier. There are some allegations that I have floated or I have not deposited some amount and some 56 baseless allegations, which is pending before their appropriate authority. But in the meantime, what they have done, when I have asked the money which is pending for Shastro Sati card, that as a revenge, they have put this
Where is your matter? Where is your matter?
No, my junior is there, they were paying for leave to move because notice given yesterday within 72 hours. Tomorrow is going to expire. But the whole process, all my nursing will be shut down.
Nursing
so,
home?
kindly take this. Yes, it's a Malda. It's a Malda nursing.
Then Friday it will be taken up? No. Friday.
It will lordship to deserve because tomorrow is the last day of the business.
Tomorrow is the last day.
Yes.
Very well. Tomorrow serve notice. Give leave. Tomorrow urgent motion. Call the list. No, sorry. No further. Yes, call the list.
So I am for the petitioner contemptor. So I favor 1 week.
Petitioner contemptor.
Contemptor.
You are for the contemptor.
Yes, I am.
Who is for the petitioner?
I am for the petitioner.
Petitioner cannot be the contemptor. Sorry.
Well, there is mistake. I am for the contemptor, and I pay for 1 week accommodation.
Well, last week also 1 week time has been granted.
No.
His voice was
My lord, I was
choked.
my lord.
Yes, now his voice has choked. What?
I pay for 1 week accommodation. My son seriously suffering from illness.
What is to be done, Mr.
Let them deposit the 25 lakhs. They have to.
Who is going to deposit?
Contempt.
Contemptor has to
Yes,
deposit. You are the contemptor.
25 lakhs
Deposit.
register. If you have division bench order, your lordship
Division
50
benches
lakhs,
are
division bench reduced to 25 lakhs.
lot of leniency shown by the division bench.
Yes.
Now it's better you go up. If you come down, no relief. Go up. From 50, you went up, it came down to 25. Go up, it will come down to 5. Or maybe it will be waived. So you go up. Nothing doing. I'm not going to hear you.
Another issue, my lord, since the occupiers not yet vacated, so corporation, the remaining job is still undone.
Who is for those persons?
The petitioner.
Petitioner himself.
Petitioner, advocate appearing for the petitioner.
লিখে নিন তো accommodation
As soon
for
My landed friend is my lord is appearing.
He is for the
He is
contempt.
all
I am for the contempt now.
তো এ কে? তো এই contempt
উনি তো petitioner হয়ে time চাইছে।
learned advocate for the petitioner seeks accommodation for a week. In view of such submission, let this matter appear in the list on 19th of February.
My lord, may I file my
In the meantime,
affidavit?
they should take proper steps to vacate and to any organization's home. Your lordship was pleased to direct to find out any home.
Two senior ladies.
2 years, my lord.
If you pay for 1 week accommodation, then the case will address.
Now these ladies are to go out.
And my senior is not able to come before the
My lord, may I file my affidavit?
Already 9 months is over.
Affidavit to the contempt application.
Achha, affidavit filed by the contemptor to the contempt application is taken on record. Let copy be circulated. Yes, it will be circulated to everybody. ঠিক আছে বলে দিয়েছি জানো।
One more thing, my lord.
আচ্ছা আরেকটা জিনিস the petitioners ought to vacate.
Happy. This direction is already there by your lordship.
তাহলে দরকার নেই let it remain.
Already there. Mother, one more thing, mother, the contemptor has to say that he has sold 1 or 2 flats.
My lord, I the contemptor, my lord, I know, my lord, what to say, what not to say, my lord. My landed friend, better, my lord.
Describe in affidavit, he has sold
See
1 or
what is there.
1 or 2 flats has sold.
See what is
Where
there in
that
the
money
affidavit.
goes.
Just see what is there.
I know, my lord, I am contemptor,
Yes,
what to
to-
say, what not to say.
Item 2.
My lord, I'm for the petitioner, my lord. On the
There are
last petition,
matters-
there was direction toward inspection of the premises, my lord.
Correct.
But on 16th, I was served with a notice from the KMC to go for the inspection, my lord. On 21st, the inspection took place, my lord. I went to the premises along with my client, my lord. But we were not allowed to enter the premises. That was not the direction of the.
Miller,
I
there
filed a
was no
supplementary
direction
affidavit.
issued by Miller, this
Miller, I have
honorable
not
court to
taken-
permit him, Miller, to be there in my premises at the time of inspection.
Very well,
Miller, he stays, Miller, in a different ward altogether. Miller, he says he's a good Samaritan. Miller, he made certain complaints as regards, Miller, my property. The KMC
Very
came,
well,
Miller,
we
they have
not forced for
inspected.
entering. I have not also prayed
These
that
allegations are
but I have
neither
not-
here nor there.
My lord, I have not prayed that I be late into the premises. I have only indicated the facts that has taken place on
So
21st
then,
of
Miller,
January.
these submissions were not required.
But I have filed a supplementary affidavit. I have served upon the KMC, my lord.
Miller, I do not know, Miller, what is written over there.
But he is
Last
not
time
a-
also, Miller, this happened.
My lord, the private
This is,
respondent
Miller,
is
my
not a-
property, Miller, with
my
regard
lord,
to which
the
matters are
private
going on.
respondent is not a party to in the contempt proceeding, my lord.
This is my property, which is, Miller, going to be demolished, Miller, on his allegation, and he says he won't serve me.
But I am filing a supplementary affidavit in the contempt proceeding. I have served the respondent. The contemners have been served.
And Miller, I'll be, Miller, kept at the bay, and Miller, my building will be demolished. Miller, I'll not be served with anything.
I want a report from the corporation.
Kindly also take the supplementary affidavit. I went to the premises, my lord.
All right, please wait.
Miller, may I be favored with a copy of the
Let
report?
me see. Yes, report will
A
be
copy of the report will
circulated.
also be handed over to you.
Everybody, what is there in the report?
Report says, my lord, the construction which was placed on the top floor, he said, but the iron, bar iron jobs which was the CI sheet, which was, my lord, the dismantle of the sheet the part is concerned, those have again been refixed.
Oh,
Again been refixed and the building has been, my lord, inspected. And the major portion of the building, as per report, my lord, that it was a residential building, but it being used for commercial purpose. And we have issued a notice, my lord, 416 in the meantime.
Lord, kindly allow me, my lord, to deal with this report.
My lord, the sum and substance of the report.
These are, my lord, beyond the writ petition. Be that as it may, when something has come, my lord, before your lordship, kindly allow us, my lord, to deal with, my lord, these allegations.
this is not the bench to take up Group 5 matters. I am dealing with the
My lord, these are
contempt.
assigned.
This was specially assigned to you, Lordship.
Both
Yes,
matters
both.
are assigned.
Lock, stock and barrel, my lord, is
All
assigned
right.
to your lordship.
My only thing, my lord, kindly take the supplementary affidavit. I have
Then let this report be circulated. Please
Great.
come.
my lord, kindly take the supplementary affidavit once. My lord, in the last order, there was direction that there may be pictures, photographical evidences be taken by the KNC. My lord, I have went there. I have taken photos. My lord, in the ground floor also there are shop rooms. In all the floor there are shop rooms. There are ad boards that shows.
Listen, 1 minute. A report is being filed today by the corporation. Go through it. If
kindly take the
required,
supplementary.
wait. If required, you can prepare an updated supplementary to help you.
Okay, my lord.
Because the corporation has already come out with
Yes.
something.
But kindly ask my learned
So
friend, my lord,
don't
why this
prejudge the issue.
desperation?
Go through the report. If you feel something more is required to be added, you can do it by taking an exception. What is the use of the supplementary?
And only thing, but they did not take the pictures. That was the
Very
direction
well.
in the
You
order.
have taken
Last
it.
order.
Put it in the exception. Ajito, report filed by the corporation is taken on record. Stop. Let copy of the same be circulated. Stop. It will be open for the petitioners. Petitioners in the writ petition and the contempt to file exception to the same by 19th. 2 weeks will be all right for the exception.
Absolutely.
List the matter on 4th of March.
Only that, my lord, we are protected till 14th of February by your lordship.
Very well, I'll extend the interim order that is subsisting in the matter of.
And item number 3. In item number 3.
What is the name of the petitioner in your matter?
My lord, I am yes. Sri Sham Projects Private.
Sri Sham Projects.
786.
Item number 3.
Huh? 3 number item is extended till 31st of March 2025 or until further order, whichever is earlier.
Grateful, my lord. Grateful.
Yes, next one.
But a copy of the report may be served up.
4 is Sri Sham. What is it?
That is a writ petition.
Writ petition, right?
No.
2, 3, 4, my lord, these are all.
All right, 4 is
Think you
also. No, 4 is a contempt. CC.
My lord, this is our contempt application. My lord, there is a contempt application, a cross contempt application.
All right, tale
Everyone says, my lord, the order has not come.
4 number ta hobe list on the 4th of March.
Grateful.
4th of March.
For the statement.
হ্যাঁ
short pass.
ঠিক আছে 2 3 একসাথে
Short pass.
আর 4 নম্বরটা সেপারেট
বলেছি দিয়েছে
হু ইজ ফর দ্য পিটিশনার
I'm for the petitioner, my lord.
yes what is it
My lord, the case is this, that we applied for a bar license,
yes
restaurant cum bar license under category 4I. Then that bar license was rejected by the collector. Then we went to the excise commissioner. The excise commissioner decided the matter with an observation that there is no order, no inquiry report, and no sketch map. And in conclusive part of the order, the excise commissioner stated that
where is it is this under challenge
yes,
order of the excise
yes,
commissioner
yes.
Page 72.
but there's a provision for second appeal isn't it
My lord, there is no provision. That is a wrong thing, my lord.
wrong thing
There's a revision.
all right
Under 8.3, there's a revision.
there is a provision
Now,
for
why we are coming before your lordship, my lord,
yes
that
because there are three contingencies in the Whirlpool case. It has been stated that if three contingencies, natural justice, fundamental right, and beyond jurisdiction, if it is passed, then that should be quashed.
Which one is attracted in this case?
In this case, principles of natural justice. How I say that, my lord? Kindly see the order, impunity order.
Page 73.
Page 73.
Yes.
On the last two paragraphs, concluding part, the injustice has been done as per the judgment of Honorable Supreme Court. Therefore, last two paragraphs your lordship has got it.
Yes, yes.
73, page 73. Therefore, the undersigned does not find any justable ground to interfere with the rejection order of the Collector of Excise, Kolkata South, Excise District. However, the Collector is reminded that while rejecting any prayer, the concerned parties need to be communicated the same, which was lacking in the instant case. The order which was not communicated to us, and we fought the order before the Excise Commission without the order. Furthermore, considering this lapse on the part of the collector, it is ordered that a copy of the inquiry report and draft sketch map be provided to the appellant within a period of 7 days. So these three documents was not there. What's the use of giving it after the case is heard? This is an injustice to us, and this contingency, my lord, may I submit the that cite this Whirlpool judgment?
No, no, sorry, don't submit.
This document was not supplied to us, and we heard the matter without those documents. Vital document.
Documents apply করে করতে বলুন চল
Admitted position, these three documents were not supplied to us. And the Excise Commissioner directed to supply to us only after the hearing. What's the use? He should have.
Very well, I got it. Yes, please.
First of all, they have annexed.
Listen, without going into all this, certain documents, the inquiry report was not given to the petitioner.
Inquiry report was given.
No, it mentions over here.
Inquiry report was given after the collector's.
It's make no sense.
But only thing, to kindly consider this. This is not a case where there is a prejudice. His contention was considered. All aspects were considered
by the appellate authority.
Appellate authority. It is not a. It's not a fundamental right. Whirlpool was cited. It's not a case. Excise is a privilege. Some latitude.
Let it be reconsidered. The court is not passing any interim order. Please come. The order of the Excise Commissioner dated 11th of December 2023. Affirming the order passed by the Collector of Excise, Kolkata within bracket South, is impugned in the instant writ petition. Stop paragraph. It appears that the Collector of Excise passed certain order against the petitioner by relying upon an inquiry report and a rough sketch map. Stop. The aforesaid two documents were not served upon the petitioner. Stop. The Excise Commissioner admits the lapse on the part of the Collector of Excise, but at the same time goes on to affirm the order passed by the Excise by the Collector. Stop paragraph. It has been submitted that the said two documents were served after the order was passed by the excise commissioner. Stop. The petitioner was not in a position to make submission on the inquiry report and the sketch map. Stop. The petitioner alleges that there has been violation of the principle of natural justice. Paragraph: learned advocate representing the respondents oppose the prayer of the petitioner. Stop. It has been submitted that the order is an appealable one. The petitioner does not have any right to obtain a license. Stop. Next. It has been denied that there has been violation of principle of natural justice and submitted that all documents were handed over to the petitioner by the in terms of the order passed by the excise commissioner. Paragraph: upon hearing the parties, it appears that the before the collector, excise, the petitioner did not have any opportunity to make submission on the inquiry report and the rough sketch map, which were used against the petitioner. Stop. Paragraph: supplying the aforesaid two documents after the order was passed by the appellate forum did not help the petitioner in any manner at the time of hearing before the collector. Stop. Paragraph: the documents being vital documents leading to the cancellation of the order, cancellation of the petitioner's license. The petitioner's license have been cancelled?
No, no, no. It's an application for a new license. Well, Lordship was dictating the order. I did not want to interrupt. Well, the sketch map and that order has not yet been given to us.
There is a direction.
The direction has been given but not yet done. So kindly ask them to give it.
May I just indicate that copy has been given. Yes, Mr. Chakraborty.
Kindly come to page 49 in their appeal. They have said the report has been given before the commissioner's order. Kindly see page 49 their appeal.
So if that be so, then how come the commissioner says that to serve the copy?
Noted. That has not been given.
No.
Because I find this is
no.
Excess commissioner
ought to have been served upon the petitioner prior to any order being passed. Stop. Next. In view of the above, the order passed by the collector, excise, and the order passed by the excise commissioner, both are set aside. Stop. Paragraph: the inquiry report and the rough sketch map be immediately served upon the petitioner. Stop. The matter is remanded back to the collector, excise for rehearing of the same afresh after giving opportunity of hearing to the petitioner at the earliest. Stop. Read petition disposed.
My lord has not gone into the merits of the matter. My lord,
it is made clear that this court has not entered into the merits of the case, and all points are left open to be decided by the respondent authority at the time of consideration.
My lord, your lordship
Yes.
may fix a time, some time. Otherwise, this will go.
Call the next one, please. Steel authority?
Tender process, the subject matter of challenges, a qualified bidder has been disqualified. I'll just briefly give you a lordship. This is in respect of a tender for dismantling of underground foundations and overground structure for the purpose of expansion of a project of ISCO in Bern. So, here, if I may just draw your lordship's attention to some of the clauses. First, if your lordship will kindly come to the eligibility clause, which is at page 20.
Yes.
This was a
e-tender, where, my lord, M junction is the electronically, or they conduct the tender on behalf of the Steel Authority of India Limited, and we are required to upload, all bidders, interested participants are required to upload all their documents, and based on whatever they upload, as per the format and as per the requirement given in the notice inviting tender, they are considered, they are found to be either qualified or disqualified, and thereafter they go to the next, which is the price bid option. So, my lord, I just wish to draw your lordship's attention to once page 20, which is the eligibility criteria. My lord, your lordship will find eligibility qualification requirements for bidders. My lord, your lordship will see on the right hand side technically eligibility criteria. Then if your lordship turns to the next page, financial eligibility criteria. So these are the criteria which a bidder is required to submit at the initial stage. Now, if your lordship kindly turns to page 24. At the bottom of page 24, your lordship will find there's a column which reads as price evaluation criteria. I'm going to kindly allow me to place this. Bidders shall fill up their quoted price. This is where we are. The issue is on this. Bidders shall fill up their quoted price in MJ Pro. This is the portal where I was required to upload it. MJ Pro portal only as per the format, and the bidders, bracket Solar Consortium, has to quote all inclusive basic price and GST against each time. I am sure, they will accept the fact that time is an incorrect word which has been gone down. It should have been item. Each item in online quotation at such and such. The bidder, sole or consortium who has quoted lowest total contract price shall be declared L1 bidder. The price evaluation will be done on the basis of total contract price as quoted by the bidders in the price schedule. Now I'll show you, lordship, my lord, another important clause which refers to reverse auction, which is 11.3.9. But kindly take once 11.3.9, which is at page 36. My lord, if your lordship will kindly come to 11.3.9 at page 37. The bidders who are considered techno-commercially eligible shall only be considered for price discovery, which can be through reverse auction or through opening of online bid price. Irrespective of the mode of price discovery, the evaluation bidders for determining L1 bidder will be based on the methodology as mentioned in the tender documents and rates quoted, obtained during reverse auction or submitted online and EPS portal. In case of RA fails, reverse auction fails or couldn't be conducted. So, my lord, once I am technically qualified and I upload all the price bid as well, so reverse auction would indicate that amongst the qualified bidders, there will be a reverse auction. Suppose, my lord, hypothetically, if I have given 100, somebody is given 90, somebody is given 80, and all three qualifies, then between 100, 90, and 80, there will be a reverse auction. Who can quote lowest? So, this is the situation. So, whatever price I indicate in my price bid, in my respectful submission may not be relevant. I have to technically qualify to go to the price bid auction. Now, my lord, here what happened is, my lord, at this stage, my lord, if your lordship will now kindly come to, on the 8th of January, I received a notice, which is at page 333, which would be third volume of your lordship's brief. This is after I upload. Page 333. Third volume. This is a mail which I received on 8th of January 2003. Please sit down. So, Lordship,
Yes.
yes, ma'am. Reference to the tender, I am not bothering your Lordship with the first paragraph. We have observed, second para, deficiencies in the documents which are listed below. Then they show serial number 5 such and such. Well, I'll just read one for your Lordship's consideration. Well, kindly take serial number 1. It says serial number 5 of checklist with reference to format of annexure 6 of commercial volume 1 in the submitted declaration. You have not included the declaration regarding no risk purchase action. Kindly include the same as per format and resubmit the declaration. Now, if your Lordship will kindly see once 3, serial number 3, and read the last sentence of 3, which says kindly submit the same. Similarly, they found a few discrepancies in the uploaded documents submitted by us. So by 8th of January mail, I was told to rectify this. Now I rectify this. And thereafter, at page 333, 334, 335, 336, your Lordship will see these are the documents which I upload and I rectify the defects. Well, there is no dispute to the fact that I rectified this defect. Now, if your Lordship will kindly come to page 337, which is an email which I received on the 24th of January 2025.
Yes.
337. This is in reference to your offer submitted against the subject tender. In this regard, it may be noted that on evaluation of your offer against the said tender, your bid has not been found as techno-commercially acceptable due to the following reasons. A, technical, nil. So, Malat, I have technically qualified. Now, kindly take B. As per ITB, that is Malat, instructions to bidders, clause 11.2.5, commercial volume 1. Now, my lord, this is the quoted portion of that clause. There shall be no indication of price anywhere in any document that is to be uploaded as part of techno-commercial bid. If prices are indicated in any document that you have uploaded, such offers are liable to be rejected. Now, my lord, thereafter in italics, they say, you have disclosed the price in part 2 of the bid. Therefore, the bid is rejected as per ITB 11.2.3. Then, my lord, they say, in view of the above, the submitted documents do not meet the eligibility criteria and your bid has been rejected. And then, my lord, at the bottom, they give me an opportunity to submit a representation. Now, before I take your lordship to the representation, my lord, allow me to place, my lord, what has happened. My lord, this document, if your lordship will kindly take the document which is at page 215.
Did you submit the representation?
Yes, I did.
All right.
Reiteration of what is there in page 333.
All right.
Nothing more than that. Now, my lord, I'll tell you, lordship, what are they saying? If my lord will kindly take once page 215, this would be volume 2.
Yes.
Well, your lordship will see this is the price schedule. Now, this is enclosure 1. Now, if your lordship reads this with this is what they are saying, that you have disclosed the price in part 2 of bid, therefore the bid. So, this is the part 2. Now, what they are saying, here in this format, I have given the prices. I am not required to give the prices. So what am I supposed to do? Now, my lord, kindly take once. This we realized later when they told us in that 24th January mail. Now, if your lordship will kindly take page 17, read this with page 17, because it took us, yes, my lord, 17. Even it took us quite some time to understand what they are trying to imply.
Yes.
Now, my lord, this starts from page 16, if your lordship will take. It says, if I may just trouble your lordship once with section A, page 16, it says the following documents as per applicability and annexure has to be uploaded by bidders. Then my lord, serial number 1, 2, 3, 4 continues. If your lordship turns to the next page, serial number 13, my lord, this is what they're pointing out. As a reason for rejection of my qualified bid, unpriced copy of price bid to be submitted with the word quoted, where price is to be quoted. Now what I have done is, in the price bid I have given the price. In the original price bid I had given the prices. Now we understood this, that unpriced copy of price bid to be submitted with the word quoted. We quoted the same price in this document also.
You should not have.
Should not have. According to them, you should have written quoted in every column. Because I did not write this, my qualified bid stands rejected. Now, my lord, look, my lord, allow me to see how preposterous this is from a tendering authority. I'll tell you.
Go into all
I'll
these
tell you,
things.
lordship. I'll tell you, lordship, why. I'll tell you, lordship, why. My lord, kindly come back to page 333. You on 8th of January
1 minute.
showed.
Prior to that, you have submitted a representation pursuant to page 337. What is
My
the
lord,
fate of it?
kindly take my representation once.
What is the fate of it?
Fate of it is final rejection at page 345, reiteration of what is there in page 333.
All right.
Same clause referred, saying that since you have quoted the price here, rejected.
Since
my lord,
you have done it
I'll tell you, lordship. My lord.
contrary to the terms and conditions,
Yes, my lord.
instructions to bidders, then what can be done?
I'll tell you, lordship. My lord. If it does not relate to the essential terms.
No, thing is, there must be a particular reason for keeping this price secret amongst the bidders, so that the bidders don't get to know what is the offered price. One doesn't get to know about the other. What you've done, you've opened it. So everybody knows that this is one of the bid. They'll bid somewhere a little more than that, or that will be difficult for the authorities.
My lord, this logic, what is falling from your lordship, would have been appropriate if it was not a reverse auction. In a normal auction, it would have been possible. Or this, they could have said this. This could have been one of their stand. But since it is a reverse auction, regardless of what I have quoted, the moment I qualify, I am entitled to go down. Now your lordship will see. Even 8th of January, when you wrote to me, you pointed out 5 deficiencies. On 8th of January, you allowed me to cure it. So this was also a deficiency. Even, well, hypothetically, if I accept what they are saying is correct, this was also a deficiency. On 8th January, I made several other discrepancies. I made several other mistakes. So you allowed me to cure all of them. Well, kindly have a look at the mail at page 333. Not one. There were more than 5 mistakes that I made.
Those were all technical.
No, my lord, I'll tell you, lordship, those were actually the real mistakes. And this is a mistake which is absolutely irrelevant to the object of the tender. Because if the object of the tender is, you are giving me a work to be executed at the lowest possible price. One, I have to be a qualified bidder for the purpose of my experience and expertise. If I qualify in my experience, expertise, and the 3 years, my amount of work that I have done, my turnover, my annual returns, my financial statements, because I have made disclosure of price where I was required to write quoted in a reverse auction situation, how is that relevant? And that is exactly what we told them. That
if
had it,
that be so, if your proposition is to be accepted, then there is no reason of maintaining secrecy. It can be an open ballot type of thing. Open auction.
It is auction.
Everybody
Open
gets
auction.
to know what is the price of the other.
Reverse auction means that all you have to do is the technically qualify.
You do not reach that stage. If
No,
I'm
but-
not wrong, I'll hear Mr.
Yes,
Gupta.
yes.
There must be other reasons also. This is what is coming to my mind offhand.
Well, Lord, actually, if your lordship, I'll tell you, lordship, if your lordship looks at that final rejection and what we said, well, Lord, what we said was that for a reason of this nature and the object of the tender and the fact that the price discovery mechanism in the auction process is via reverse auction, even if I have made this mistake, which is, of course, my incorrect understanding of the clause. Because you said quoted. Malad, if your lordship really look at this, there's ambiguity in the clause.
Please do not. Yes,
No,
Mr.
Malad,
Gupta.
I will just make one submission, madam.
What is the reasoning? There is a reverse auction when the bidders get to know.
I'll come to the reason.
Yes.
The justification for this. But possibly that will not be necessary because of the tender terms themselves. If your lordships kindly come to page 17.
Before Mr. Gupta, Malad, may I just show your lordship two more clauses? No, Malad, that is the
very
reason. Malad, since I am primary, I can understand, Malad, that your lordship is not with me. I just wish to show two clauses. Malad, there is a specific clause in the tender on which grounds they can reject. If there is a specific clause in the tender that these are the grounds for rejection at the pre-qualification stage, so Malad, they could have only rejected me on those grounds and in no other grounds. So, Malad, that is number one.
And I adopt his submission.
Malad, allow me to show that, Malad. If your lordship will kindly see the grounds of rejection at page 43. Malad, because I have made a mistake, Malad, you being a public authority, you are required to act in accordance with equity, fair play, and justice. Malad, this is, Malad, if your lordship will appreciate also, Malad, even in fact, Malad, in a case which went up from the Calcutta High Court before the Honorable Supreme Court, Rashmi Metallic, Malad, something like this happened. Malad, one of the bidders, which was the appellant, Malad, did not disclose, Malad, the PAN details and the financial statement. And Malad, our writ petition before the Calcutta High Court stood rejected. Malad, allow me to, after this clause, I'll show your lordship that judgment. Malad, kindly take once page 43. So there your lordship will find what are the grounds available to the tendering authority for rejection. Malad, from 20.12.1 till 20.12.7, your lordship will find these are the grounds of rejection at the qualification stage. Now, what they are referring to is 11.2.5, which is at page 36. at 30. They say that if prices are indicated in the in any document that are uploaded, offers are liable to be rejected. Now, just because I have indicated the price in a document where I had to write quoted, my price is rejected. Now, even assuming that this is their authority, where is the, since in a reverse auction situation, how is that relevant?
No, please. Yes, Mr. Gupta.
There has to be some amount of rationality in the decision-making process by the tendering authority.
The auction process after going through all this, and then you say, what is the use? No, it makes no
if
sense.
9th January letter had not come, I would have said. So they could have pointed this out on the 9th January that you made a mistake.
17, yes. 17.
Clause 13.
13. Unpriced.
Unpriced copy.
Right.
Of price bid to be submitted with the word quoted.
Hmm.
Where price is to be quoted in enclosure 1. My learned friend shown to your lordship enclosure 1. Price, there is a column regarding price. Only thing was to be to state is to quoted, nothing else. Then kindly come to 32. Page 32. Clause 11. The tender is to be divided in 3 parts. Part 1, EMD. That's the earnest money deposit. Next, part 2, techno commercial bid. And part 3, price only. Other than this, nothing. Then kindly take page 30, page 58. I straightway come to page 58. There are other pages to be shown.
11.3.9 bidders who are considered techno-commercially eligible shall be participate for price reverse auction.
Kindly take only one, page 37.
Page
37.
Price discovery
Page?
Page 37.
37, yes.
11.3.9.
Yes.
At the top.
Yes.
The bidders who are considered techno-commercially eligible shall only be considered for price discovery, not at the pre-decision stage. who are considered techno-commercial eligible shall only be considered for price discovery, not before that. And then we'll kindly come to page 58.
Yes.
38.
58.
58, clause 38.
Yes, rejection.
Rejection. The bid shall be rejected
Uh,
under the following conditions. Come to the last one, 7. Bids containing filter price in techno-commercial part 2 shall be rejected. It's a mandatory condition, my lord. There is nothing, no option open to the authority. And my lord, I have brought some judgments, my lord.
no, please. Please come.
My lord, may I just indicate this, my lord? Mr. Gupta's referred to, my lord, clause 38 at page 58.
59.
My lord, 58.
And my lord, page
Then
59. Once more, my lord, page 59 only.
Non-negotiable terms and conditions.
Clause 39 at page 58.
Hmm.
Non-negotiable terms and conditions. Non-negotiable. And then 3, now B. Next page, page 59. B. Submission of online bids in 3 parts.
First party, second party.
If it is done in the second part, then nothing remains in the price bid to be submitted. He's disclosing his price. Everybody knows of it. He can control the entire the bidding system.
Acha.
my lord, may I just,
Judgment, sir, I need not show to you.
my lord, since your lordship, may I just give one clarification?
No
It is
clarification.
of-
I'm not with you from the word go.
No, I can understand that, my lord. Why I'll tell you, lordship, my lord. What they are trying to say is factually incorrect. All price bids have already been uploaded at the inception. All 3 parts have been uploaded. So what they are saying, that discovery part, my techno-commercially qualified bidders will be considered in the next part. That is correct. So I am saying I have technically qualified. You have said that in 333, that technically qualified nil. Then, but you reject me because I have given a wrong format.
Acha. The petitioner.
So that I was relying upon one
Participated.
Supreme Court judgment, one paragraph of a Supreme Court judgment which went up
Excuse,
from
no.
this court.
No. The petitioner participated in the auction process. Tender process conducted by Steel Authority of India Limited for এই যে 14 নম্বরটা লিখে নেবেন তো ডিসম্যান্টলিং থেকে বার্নপুর স্টাফ the bid of the petitioner stood rejected on the ground that the bidder disclosed the price in part 2 of the bid, which is contrary to the terms and conditions of the tender. Stop. Paragraph. According to the petitioner, the price was disclosed because of improper understanding of the terms and conditions of the tender process. Stop. Instead of mentioning the expression within quotes quoted, comma, the petitioner has wrongly mentioned the price over there. Stop. It was not the quoting of price was not deliberate and it was a mistake. Stop. It has been contended that as a reverse auction system has been mentioned in the tender document for selecting the L1 bidder. Accordingly, mere quoting of the price ought not to be the reason. Quoting of the price at the initial stage ought not to be the reason for rejection of the bid of the petitioner. Stop. Paragraph. It has been submitted that as the petitioner was qualified technically, he ought to be treated as a successful bidder and should be permitted to participate in the reverse auction bid. Paragraph. Per contra, learned senior counsel representing sale draws attention of the court to the instructions given to the bidders, which clearly mentions that an unpriced copy of the price bid is required to be submitted with the word within quotes quoted, where price is to be quoted in enclosure 1. Stop. The documents comprising the bid na the documents are aage under the clause na heading, under the heading documents comprising the bid, comma, it mentions that the offer / bid submitted by the bidder shall comprise of 3 parts / components. Part 1, EMD, caps দিয়ে, ব্র্যাকেটের ভেতরে, or bid security, bracket close / bid securing declaration. এটা লিখে নেবেন তো পেজ 32 থেকে এই তিনটে। The part 3 contains the price bid only. Stop. আচ্ছা। Clause 11.3.9 of the bid document mentions that the bidders who are considered techno-commercially eligible shall only be considered for the price discovery, which can be through reverse auction or through opening of online price bid. Bracket is submitted on EPS portal. Stop. Irrespective of the mode of price discovery, comma, the evaluation of bidders for determining L1 bidder will be based on the methodology as mentioned in the tender documents. Page 37 e ache. And rates quoted / obtained during reverse auction or submitted online on EPS portal. Within bracket, in case reverse auction fails or couldn't be conducted. Stop. Under the clause rejection, it has been mentioned that the bid shall be rejected if the bid containing filled up price is mentioned in the techno-commercial part, within bracket part 2, and আচ্ছা part 2 ওখানে stop করে দিন paragraph. It has been submitted that the entire auction process will turn out to be faulty if the bidder quotes the price prior to the bid discovery stage. Stop paragraph. Upon
Lordship.
hearing the submission made on behalf of both the parties and on perusal of the documents placed before this court, it appears that the petitioner disclosed the price prior to reaching the price discovery stage. Stop. The same is contrary to the terms and conditions of the bid document. Stop. The petitioner may not have understood the terms and conditions of the tender document properly and may have incorrectly disclosed the price.
May I have your Lordship's kindly one?
Yes. In the initial stage. Stop. The same is contrary to the terms and conditions of the bid document. Stop paragraph. The court does not find any error on the part of the respondent authority in rejecting the bid of the petitioner. Stop. No relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
Keep your
If you will start. জানা বাবু আপনি কি আপগ্রেডেড নম্বরগুলো লিখেছেন? আপনি এখান থেকে
May it please your lordship. I had given a list of dates to my lady last time. Does your ladyship have it?
1 minute, please. Yes.
I had given my lady a list of dates last time.
Yes.
Does your ladyship have
Yes, yes.
Now, just a couple of minutes to state the facts, although that is not an issue before your ladyship now. I remitted money to a Singapore bank under what is known as Liberalized Remittance Scheme, LRS. That's perfectly legal and allowed under the RBI. Nobody has said that that was wrong. I invested it in a Singapore bank and used that money for trading in securities, buying and selling. I also borrowed some money from that bank to trade in securities. After about 2 years, I closed that trading account and repatriated the money. Whatever I had borrowed from the bank, I had paid the bank.
But then factually, there is no dispute.
No, that's why I said 2 minutes to
All
give
right.
the background. It's not in dispute. I remitted the money back, whatever money I had taken from the India to the Singapore bank, and the profits were repatriated and taxes paid. There's no allegation about that. The allegation is that for borrowing from the Singapore bank, I should have got prior permission from the RBI. That's the allegation. Now, whether it's correct or not is again not for your ladyship to decide, but that will be decided by the RBI or whichever the authority is. The Enforcement Directorate Special Director, now kindly see the list of dates. It'll take 2 minutes again to complete it. 31/2/2011 to 8/2/2013, the transactions took place for about 2 years. Sit down, don't stand up. 18/11/22, show cause notice issued by the Special Director, Enforcement Directorate. 21/22, first compounding application filed by petitioner to the RBI, which is the compounding authority. 8/1/24, first compounding application return, saying that you had not given all the particulars, information, etc., with liberty to file a fresh compounding application. Before I filed the first fresh compounding application or decided my course of action, the Special Director passed an adjudication order on the show cause notice, imposing a penalty of 10 crore. That is an issue here. Then I filed the fresh compounding application. The fresh compounding application on 11/9/24 was rejected by the RBI and returned as not maintainable by stating that compounding cannot be done once adjudication order is passed. I filed a writ petition. In the meanwhile, before the writ petition could be listed, the demand notice was issued and the second writ petition was filed, making the Enforcement Directorate a party. And then last time, your ladyship was pleased to allow accept my request. So the first writ petition is subsumed in the second writ petition. That may be withdrawn and dismissed. That has been withdrawn and dismissed. Now WPA 2065 is before. The only question of law is, after an adjudication order, can a compounding application be filed? That's the very short question. Now kindly see this compilation, because once, if your lordship holds that a compounding application is maintainable, end of the matter, then the adjudication order will take over and whatever remedy I have against the adjudication order will have to be pursued. If your ladyship holds that a compounding application is maintainable, then the RBI order rejecting my application has to be quashed and they have to consider the compounding. Now kindly have the compilation.
Yes.
Kindly see FEMA. Section 4.
The same compilation submitted on the last occasion.
Yeah.
We have a copy.
You must be having the act with you.
But I believe that it is not only the act. There are certain more things.
It's all right. You can have a copy. You can have a copy. Now kindly see section 4. I'll quickly run through it. Section 4, save as otherwise provided in this Act, no person resident in India shall acquire, hold, own, possess, or transfer any foreign exchange, foreign security, or any immovable property situated outside India. Not material to the issue, just giving the background of the law. Then section 13, penalties. If any person contravenes any provision of this Act or contravenes any rule, regulation, etc., he shall, upon adjudication, be liable to a penalty up to thrice the sum involved in such contravention, where such amount is quantifiable, or up to 2 lakh rupees where the amount is not quantifiable, and where such contravention is a continuing. So it's penalty for violation of section 4. Then section 15. Page 18. Any contravention under section 13, any contravention under section 13 may, on an application made by the person committing such contravention, be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officers of the Director of Enforcement and officers of the Reserve Bank of India as may be authorized on this behalf. There are 2 compounding authorities. My lady may note under section 15, there are 2 compounding authorities. One is the Enforcement Directorate, one is the RBI, depending upon which is the section violated. That will come in a moment. Where a contravention has been compounded under subsection 1, no proceeding or further proceeding, as the case may be, shall be initiated or continued, as the case may be, against the person committing such contravention under that section in respect of the contravention so compounded. Now, if your lady will kindly read section 15 again. Any contravention made by the person committing such contravention be compounded. So somebody must find me committing a contravention, and then only the question of compounding arises. Suppose I am discharged of the alleged offense, then I don't have to compound anything. It's only on authority finding that I've committed a contravention, the question of compounding arises. Now kindly see section 16. For the purpose of adjudication under section 13, the central government may, by an order published in the official gazette, appoint as many officers as the adjudicating authority. They have appointed an adjudicating authority. We are not on that. Then the rest of the section reads, adjudicating authority shall hold an inquiry. Said a person may appear either in person. Every adjudicating authority shall have the same powers of a civil court. Every adjudicating authority shall deal with a complaint under subsection 2 as expeditiously as possible, provided that where the complaint cannot be disposed of, adjudicating authority shall record the reasons. Now kindly see section 17. Against an order of an adjudicating authority, there are 2 appellate forums. One is under 17, appeal to the Special Director Appeals. The central government shall by notification appoint one or more Special Directors Appeals within the Enforcement Directorate to hear appeals against the orders of the adjudicating authorities under this section, and shall also specify in the said notification the matter and places in relation to which the Special Director Appeals may exercise jurisdiction. That's 45 days, etc. Now kindly see 18. The appellate tribunal constituted under subsection 1 of section 12 of FEMA shall, on and from the commencement of part 14 of the chapter 6, be the appellate tribunal. They have adopted another appellate tribunal as the appellate tribunal. That doesn't detain us. Then 19. Appeal to the appellate tribunal. Save as provided in subsection 2. The central government or any person aggrieved by an order made by an adjudicating authority other than those referred to in subsection 1 of section 17, or the special director appeals may prefer an appeal to the appellate tribunal, provided that any person appealing against the order of the adjudicating authority or the special director appeals levying any penalty shall, while filing the appeal, deposit the amount of such penalty, etc., etc. Every appeal, etc., etc. All that is normal provisions. So, there is one appellate forum special director against certain orders. Appeal is to the special director. Where the order is passed by the special director himself, the appeal is to the appellate tribunal. I hope I'm making myself clear.
Yes.
For the special director, our case is special director. Our case is a special director has passed the appeal. So there can't be an appeal to the special director. The appeal is to the special appellate tribunal. But some other officer of the enforcement directorate could have passed the appeal, depending upon his territorial and monetary jurisdiction. And then the appeal would lie to the special director of the enforcement director. But if the special director himself passes the adjudication order, the appeal is to the appellate tribunal. So there are two avenues of appeal. That's all that I want to show in the Act. Now kindly see compounding rules. Serial number 3, 67. Issue Rule 11. No contravention shall be compounded if an appeal has been filed under section 17 or section 19 against an adjudication order holding a person has contravened a provision and is liable to a penalty under section 13. If I file an appeal either under section 17 to the special director appeals, or in a suitable case under section 19 to the appellate tribunal, it cannot be compounded anymore. It supports my interpretation of section 15 that a compounding will arise only after somebody finds that I have committed a contravention. Before committing a contravention, I cannot compound. Section 15 and section 11. Now, kindly, my lady may read it. Section 15 at page 18 and Rule 11 at page 17. Please keep it side by side and read it. Any contravention under section 13, which according to me is clear enough, any contravention under section 13 may, on an application made by the person committing such contravention, be compounded. But no contravention shall be compounded if an appeal has been filed. So either I can compound after the contravention is found against me, either I can compound or I can file an appeal. If I file an appeal, I cannot compound. The submission is compounding can be done only after contravention is found, but before an appeal is filed. That gap alone, I can file a compound. Now kindly see what else. No, this is not necessary. Now kindly see serial number 4, master direction. It starts at page 73. This is issued and updated in 2016. My case, the show cause notice was issued in 2022. Look at paragraph 2. Instructions issued on compounding of contraventions under FEMA have been compiled in this master direction. The list of underlying circulars which form the basis of this master direction may bring the instructions contained in this master direction to the notice of the constituents. The master direction will be updated from time to time as and when fresh instructions are issued. Now kindly come to page 81. Six 6.4 is 6.3, not necessarily. 6.4 is the relevant instruction explaining the act and the rules and how will they apply. In case where adjudication has been done by the Directorate of Enforcement and an appeal has been filed under section 17 or 19, no contravention can be compounded in terms of Rule 11. Simply repeating Rule 11 in simpler language. The applicant shall confirm in the undertaking required to be furnished as per Annex 3 along with a compounding application that they have not filed an appeal under section 17. This reinforces my argument. Compounding can be done only after adjudication, but before an appeal is filed. Now kindly see Annexure 3. Is it there? No. Okay. Annexure 3, in the compounding application, I have to give an undertaking that I have not filed an appeal. The rule, the instruction is clear. Then what else? No, what is this? Now, what is the contravention found against me? Because that will depend upon who is the compounding authority. Which is the section which says compounding authority in 3A is Rule 4. Yes. Now kindly see the compounding rules. It starts at page 67. Rule 4. I should have shown that. I'm sorry. Rule 11 I read. Rule 4. Kindly see Rule 4 at 68. I'm sorry I skipped that, missed that rule. RBI is a normal compounding authority. The rule will make it clear. Kindly see Rule 3, previous page. Compounding authority means the persons authorized by the central government under subsection 1 of section 15, namely an officer of the Enforcement Directorate not below the rank of Deputy Director, an officer of the Reserve Bank of India. Over the page, 4. If any person contravenes any provisions of FEMA, except clause A of section 3 of that act, in case where the sum involved is so-and-so, the Assistant General Manager of RBI. In case where the sum involved is 10 lakhs but less than 40 lakhs, Deputy General Manager of RBI. In case where the sum involved is 40 lakhs but less than 100 lakhs, General Manager of RBI. In case where the sum involved is more than 100 lakhs, but the Chief General Manager. So RBI is the authority, normally, for all contraventions, except where section 3A is contravened by FEMA. Then it becomes the Enforcement Directorate. Now kindly see Rule 5. If any person contravenes the provisions of Section 3A of the Foreign Exchange Management Act, the Deputy Director, the Additional Director, the Special Director with Deputy Legal Advisor, and then the Director. So the compounding is divided into two parts. If violation is of 3A, Section 3A, the ED officers are the compounding authority. If any other contravention, it's the RBI. It again reinforces my argument that compounding can be done only after adjudication. Otherwise, it's meaningless. I mean, before the adjudication, I can't compound. I must know, number one, which is the section I've violated. If I have violated Section 3A, the compounding authority is the enforcement directorate. If the violation is of any other section, I will have to apply the RBI. Then who is the authority will also depend upon the amount involved in the contravention, because there are gradations. Therefore, my basic point is compounding can only be done after adjudication. Now kindly see. Now kindly see the adjudication order. What am I found guilty of? The adjudication order starts at WP. Which page? No, where it is start? Order starts at page 84. Order starts at 84. I'm not reading, it's a long order. Only one page I have to read. Starts at 84 in the main writ petition. Kindly come to 135. Actually, the last 10 lines. Alleged contravention of provisions of Section 3A and 3B. 3A is the special section, which compounding is the ED. All other sections, the compounding authority is the RBI. So 3A becomes relevant. What am I guilty of according to the adjudicating authority? As regards the alleged contravention of provisions of 3A and 3B of the Foreign Exchange Management Act, for the sake of discussion and easy reference, I hereby reproduce the relevant provisions. Then, I find that the adjudicating authority, I find that alleged contravention of Section 3A is not sustainable, as it is not a case where noticee have dealt in any foreign exchange or foreign security or transferred any foreign exchange or foreign security to any person who is not an authorized person. Since all the transactions have taken place through a bank, therefore, alleged contravention of Section 3A is not legally sustainable. I also find that the alleged contravention of Section 3B is not sustainable, as it is not a case of making any payment to or for the credit of any person resident outside India in any manner, otherwise through banking channel, instant cases not of hawala transfer or to transfer money abroad through informal unauthorized channel, since all transactions have taken place through bank. Therefore, allegation of contravention of 3B is also not legally sustainable. So I have been exonerated of 3A. If moment I'm exonerated of 3A, the only compounding authority is the RBI. Only in 3A, the ED becomes the compounding authority. Now I file an application for compounding. Now kindly have the list of dates. I'll finish in another 5 minutes. Kindly have the list of dates. Adjudication as order is passed on 28/3/24. Finding me guilty of some other section, not 3A. Penalty is how much? penalty of 10 crore is imposed. I see the order. I see the penalty. Your Lordship may now kindly look at it from the affected person's point of view. He sees the order. He first has to see what is the penalty. Suppose the penalty is 10 lakhs. I may decide I won't compound it, I won't appeal it, I'll pay the 10 lakhs and go. So depends upon the penalty, number one. Number two, depends upon which is the section I've violated. If it is 3A, I must file it to the ED. If it is any other section other than 3A, I'll have to file it to the RBI. So I cannot decide the compounding authority unless I see the order. Therefore, I see the order of 28/3/24. I find that it is passed by the special director. Appeal is to the appellate tribunal and has imposed a penalty of 10 crore, but it does not find me guilty of 3A. Therefore, I decide, since the amount is 10 crore and I have not been found guilty of 3A, I file it to the RBI. RBI, I file it on 10/5/24. It is rejected on 11/9/24. Now kindly see the order of rejection, 165. WP 165. It's a short order. Please refer to your application dated May 10, received in Reserve Bank of India on May 13, seeking compounding. In this connection, since the adjudication order has already been passed by the adjudicating authority with respect to the contraventions applied for in your compounding application cannot be processed. Therefore, the caption compounding application is being returned. The only reason is adjudication order has been passed, therefore I can't compound it. Where is the compounding application? Now kindly see the compounding application which has been returned. It starts at page 141. Page 3A mentioned. Now at paragraph 5 at page 142, I have been held guilty of contravening regulation 3, not section 3A. That your Lordship saw at page 134, 135. Then paragraph, page 147, paragraph 6.12. It should be further noted, applicant has not filed an appeal under section 17 or 19. Because moment I file an appeal, I lose the right of compound. Which page? Now kindly see which paragraph. Then I conclude my application at 152 and at 153, kindly see mail ID. Any other information relevant to the case Applicant herein undertakes to provide any other additional information as might be sought. Furthermore, the applicant also seeks the indulgence of this compounding authority to provide it a personal hearing in the matter so as to enable the applicant to place its submission in more detail before a decision is arrived at in the matter. Am I entitled to a personal hearing? Yes, the section says so. Kindly see the FEMA, the compilation, page 70. Page 70. This is Rule 8, Sub-Rule 2 at page 70. The rule starts at 69. The compounding authority shall pass an order of compounding after affording an opportunity of being heard to all the concerned as expeditiously as possible and not later than 180 days. Therefore, natural justice is inherent. It is also specifically mentioned in the rule. Now, my complaint is, and I'm concluding, my complaint is one, the basis of rejection is wrong. Because adjudication order has been passed, you cannot compound, is to be stated to be rejected. I'm sorry, I'm borrowing a judge's language. This argument is hollow. Compounding can only be filed after adjudication. And I must know which offense I have committed. Depending upon that, I will choose the compounding authority. Second, I must know what is the penalty. If it is a minimum penalty, I may not compound or appeal. If it is a case which I think, or my legal advisor tells me, this will be set aside an appeal. Why don't you file an appeal? Why should you pay compounding charge? I may file an appeal. The alternative available is I may file a compounding. All these avenues are open to me to decide whether an appeal should be filed or compounding should be filed. If a compounding should be filed, to which authority should I file the compounding? And what is the compounding amount? The compounding amount is a matrix. Your Lordship see the matrix at compilation page 83. All that is for the RBI to decide. The matrix is there at page 83. Guidance note to the compounding authorities. This is the matrix. It says for this offense, this amount, what is the compounding? Your Lordship need not go into it. So I have a choice after the adjudication. One, I'm sorry, I'm repeating myself. I'll conclude. I won't repeat myself again. One, whether I should accept the penalty order and pay the penalty. That's available. One. Two, whether I should file an appeal or I should file a compounding. If my case is so strong, my legal advisor says appeal will be allowed, I can go to the appeal. I don't have to pay the compounding fee. If I decide to file the compounding, I must know which is the authority, 3A or any other section. Then I can file a compounding. Looking at the matrix, I keep 10 crore at one hand and the compounding matrix table, and I decide this is advantageous to me and I'll do it. Therefore, my submission is I can only file a compounding after adjudication, number one. And before the RBI rejected my application or returned my application, it is bound to give me a hearing. I propose to return your application because you cannot file a compounding application after adjudication. I would have explained that. What I'm explaining to your Lordship, I'll explain it. Anything else? Milord, I think, although it's not for your lady to decide, it's RBI to decide. I think the compounding in this case, I have compounded it. I've calculated it, not compounded it. I'm sorry. I've calculated it at page 154 of the writ petition. 154. It's not binding on your lordship. I've compounded it. It amounts to about 21 lakhs. 21 lakhs. Therefore, I think it's advantageous for me to compound it. Since the RBI is the compounding authority in this case, I'll approach the RBI. I'll pay 21 lakhs according to the matrix. Why should I pay 10 crore? Therefore, the impugned order is illegal, without jurisdiction, based on a totally misdirection of law, that a compounding application cannot be filed after adjudication. I pray that the writ petition be allowed and the order returning the compounding application be quashed and the matter remitted to the RBI to compound the matter in accordance with law. Those are the submissions. There is a demand notice issued. I filed the writ petition on 31. I filed the writ petition on 13/12, and before it's listed, they came on 17/1.
Page
If the lordship
166.
accepts my case and quashes the RBI order and directs the RBI to compound it, obviously the demand notice issued by the assistant director will have to be set aside. Those are my submissions. I'm grateful.
Yes.
Please, Your Lordship. My Lord, I'll try to make good, my Lord, our contention, which Your Lordship has
Who are you representing?
My Lord, Reserve Bank of India, my Lord, respondents 1 and 2. It is, my Lord, our order which is under challenge, because we have said that it is too late to file for compounding once the adjudication process is over. Now, my learned friend, my Lord, is arguing that the process for compounding will only start after the adjudication process is over. My Lord, I respectfully submit, my Lord, that that is not the scheme of this legislation at all. It is the other way around. So, my Lord, Your Lordship will kindly now, I'll quickly take Your Lordship through the scheme of this act and then also the rules, because the rules support that position, my Lord. First comes the contravention. My Lord, I am trying to, my Lord, create the stages which will arise in a matter like this. First comes a contravention by a person, a private person, my Lord. Now, whether he is contravening or not, that is for him to decide in the first instance. When he contravenes, then Section 13 comes into effect. Section 13 does not end with an adjudication. It starts with a contravention. So, my Lord, the first step is that there is a contravention. The second step is, my Lord, that proceedings commence under Section 13 and 16. My Lord, 16, though it says it is about the appointment of an adjudicatory body, it is actually the section which lays down what will happen if there is a contravention, how the process will start. Then, my Lord, will come the procedure to be followed in the adjudicating proceedings, which is contained in Section 16. My Lord, it's a little scrambled, my Lord, so I am trying to unscramble that, my Lord. In the meantime, it is our contention, my Lord, in the meantime, a person is at liberty to apply for compounding. That is under Section 15. But if he allows the process of adjudication to complete itself, after that, apart from an appeal under Section 19, he has no other option available to him. The compounding process is not available to him anymore. So, keeping this, my Lord, then, my Lord, what remains is only the enforcement, that is Section 14, and the recovery of the penalty amount, which is Section 14 capital A. So, this is, my Lord, the scheme according to us. Now, my Lord, if I may take Your Lordship through those sections a little carefully, my Lord, because Your Lordship is called upon to decide what is the stage at which a compounding application should be made. In making the submission that it is possible to make a compounding application after the date of adjudication, my learned friend has fallen upon a primary principle according to him that it cannot in fact be made at any stage prior thereto. These are two different propositions altogether. It is possible to say that an application for condonation, for compounding can be made before the adjudication process is over, but I would still have the liberty to make an application after the adjudication process is over. That's a possibility. But that is not, my lord, the route that my learned friend seeks to take. My learned friend wishes to say that the process of condonation, that is section 15, does not at all commence till an adjudication is completed. My lord, this is a fundamental error in the argument. And my lord, the most important aspect which will clinch that point is subsection 2 of section 15. But my lord, I don't want to jump the gun. I want to take your lordship one by one through the scheme. The scheme starts with, my lord, various provisions which has to be complied with by anybody dealing in foreign exchange. Then comes, my lord, section 13. Section 13, if my learned friend has now placed it in a compilation, but your lordship has it anyway. Penalties. If any person, your lordship has that, my lord?
Yes.
If a person contravenes any provisions of this act or contravenes any rule, regulation, notification, direction or order issued in exercise of the powers under this act, or contravenes any condition subject to which an authorization is issued by the Reserve Bank, he shall, upon adjudication, be liable to penalty. That's, my lord, the sum and substance of this section. So, first step, he has to contravene. This does not, my lord, require RBI at all, or the Enforcement Directorate. Whether he is contravening or not is an act which is completed as soon as he has contravened it. Now, next, my lord, we come to the nature of the proceedings which will happen if section 13 contravention has taken place. I am not saying, my lord, that a section 13 contravention has been found. There are two very different things, my lord. Whether a contravention has taken place does not require a finding by an adjudicatory body. It has taken place. Of course, my lord, consequences will not follow until it is adjudicated. True. But the contravention does not depend upon adjudication. Adjudication follows to decide whether or not the contravention has taken place. The contravention takes place as soon as you violate any provision of the Foreign Exchange Management Act. Now kindly come to 16, because logically, my lord, it is 16 which follows after, my lord, a contravention takes place and is found. Please see 16. Though it starts by saying appointment of adjudicating authority, your lordship will find that this is the section which deals with how the adjudication will take place altogether. May I place 16 now, my lord? For the purpose of adjudication under section 13, the central government may by order, etc., appoint officers for holding an inquiry. That's number one. So an officer will hold an inquiry in a manner prescribed. So, my lord, there will be rules. After giving a person alleged to have committed the contravention under section 13, against whom a complaint has been made under subsection 3, hereinafter in this section referred to as the said person, a reasonable opportunity of being heard. So, my lord, it is jumbled up, as I told your lordship. It doesn't, my lord, go one by one, step by step in the logical order. So what happens if a contravention has taken place and is only alleged? After that, my lord, comes subsection 3. Of course, my lord, in between the central government will notify adjudicating authorities. That's, my lord, a general proposition. It does not depend on any particular case. So the next step is really subsection 3 of section 16. No adjudicating authority shall hold an inquiry under subsection 1 except upon a complaint in writing made by an officer authorized by general or special order. So if a contravention takes place, the next step is an complaint by the authorized officer. The next step is an inquiry. When an inquiry is started, it must be done in a prescribed manner and after giving a reasonable opportunity to the person of being heard for the purpose of penalty. So, my lord, section 16, if your lordship reads carefully, leads to these concurrent steps 1, 2, 3, 4, 5, but they are not in the correct order. Your lordship sees, my lord, that subsection 3 is the first step, then is the inquiry, which is subsection 1, and then, my lord, subsection 1 contains the rest of the procedure, which is manner prescribed and reasonable opportunity. So this is section 16. Yes, I know. So, my lord, there has to be a contravention, then it must be followed by a complaint. After the complaint, there will be an inquiry before the authority. Now, when this application or, my lord, complaint is pending, it is at this stage that my learned friend's client has to make a choice. He has to choose whether to apply for compounding at all or not. And, my lord, the simplest way to demonstrate this, my lord, is to show your lordship section 15 now. Because 15, my lord, is an option which becomes available to him. And, my lord, it becomes available to him even before the initiation of a process. Because he has contravened. And somebody has alleged it, let us say, or somebody has not alleged it, let us say. Let us say, my lord, it has come to his attention by some other process, in consultation with his lawyer or his banker or whatever. It has come to his attention that a contravention has taken place.
Is contraventions, are the contraventions mentioned somewhere?
Yes, my lord, the contraventions are the rest of the provisions of the Foreign Exchange Management Act.
All right.
For instance, my lord, section 4 is the nature of a contravention. Section 3A is the nature of a contravention. 3A says that you have dealt with somebody who is not an authorized dealer. Now, if you deal with somebody who is not an authorized dealer, it becomes a contravention. So, a contravention is simply violating any provision, substantive provision, my lord, not procedural now. Here we are dealing only with the procedural provisions. But, my lord, there are several provisions which are only substantive, which tell you what you can or what you cannot do with foreign exchange. These are the contraventions which are listed. You have to look at all the sections and see whether you have in fact committed a contravention or not. Now, please see, my lord, section 15.
Then isn't any authority required to bring it to the notice of the person concerned? See, look here, this
My
is
lord,
the contravention.
in this case, it was, and in
was.
most cases, it will be.
All right.
But, my lord, there is a possibility that he can apply for compounding even before any process has started.
After he notices it voluntarily.
After he notices it. My lord, after all, my lord, a compounding is something which is where you have perhaps without or inadvertently transgressed the law. That's the kind of situation which
when you get to know that you have transgressed,
yes,
prior to that, you do not know, or you seem like you do not know.
Assume that he doesn't know, then at least he gets to know when the complaint is filed. That is the last possible moment till which he may be under an apprehension that he hasn't committed. But what I am trying to establish before your lordship is that even before initiation of a process, he can apply for compounding. So now, my lord, please see section 15 carefully. Because that's, my lord, the heart of the matter. Section 15, power to compound contravention. Any contravention under section 13 may, on an application made by a person committing such contravention, be compounded within 180 days from the date of receipt of application by the Director of Enforcement or such other officers as may be authorized in this behalf by its central government in such manner as prescribed. So, my lord, all that is necessary to trigger section 15 is a contravention. We are not, my lord, an adjudication. There is nothing which says that the adjudication will trigger section 15. Now see subsection 2, very critical. It gives your lordship, my lord, a clear idea what this power is. Where a contravention has been compounded under subsection 1, no proceedings or further proceedings, as the case may be, shall be initiated or continued, as the case may be, against the person committing such contravention under that section in respect of the contravention so compounded. So, my lord, even before the initiation of any proceedings, he can apply for contravention and compound it. Where a contravention has been compounded, no proceedings will start or continue. This is very critical. A process may not even start. So if you have compounded, then thereafter, neither the Reserve Bank nor the Enforcement Directorate, as the case may be, will even take up for consideration a proceedings for adjudication at all, complaint. So it will neither be initiated if it hasn't yet been initiated, nor will it continue if it has been initiated. But both these two are situations before adjudication. Both the situations contemplated in section 15(2), that is to say, an initiation or continuation of a proceedings under section 13 and 16, both these two are prior to the completion of that process. Does your lordship, my lord?
So no proceeding or further proceeding would include adjudication?
It would include only adjudication.
And why not appeal?
My lord, that will come to in a short while. I'll come to that point also.
Yes.
But certainly, yes, a proceeding, an appeal is a proceedings. To that extent, my lord, I would agree. But my lord, it won't come into effect for a reason I shall indicate in a few minutes. But kindly see, my lord, 15(2) puts an end to the argument that prior to the adjudication, I cannot apply for compounding, which is the principal plank on the basis of which my learned friend has made his argument.
Sorry, my lord, I didn't argue that at all.
I'll hear you in reply.
No, he's misstating my argument. My argument is, after adjudication, have I a right to compound? Obviously, if a show cause notice is issued, I admit my guilt. Before adjudication, I can compound, but that is not the situation here. The question is, he is talking about a hypothetical situation. I admit my guilt, then why should there be an adjudication? Moment I compound, I have to admit my guilt and compound it. That is not the situation we are dealing with it. Therefore, I did not address any arguments on whether before show cause notice, before adjudication, I can compound. That is not the situation. Question here is, after adjudication, can I compound? That is the only issue I'm addressing.
So, my lord, my notes, my lord, clearly shows multiple times my learned friend has repeated that till adjudication is complete, I don't even know. So I cannot start compounding also.
I won't admit the guilt.
So, my lord, as far as my learned friend is concerned, of course, he's free to, my lord, modify his argument. I'm not saying. I have to meet both the arguments. But the basis that I can only start after adjudication is clearly, my lord, not correct. Now, my lord, according to the scheme that I have drawn up, my lord, 13, 16, and while the proceedings are going on under section 13, he has the option of compounding, section 15. So after 13, it can be 16, and then it could be 15 or continuation of 16. Either he compounds and tells the tribunal, tells the authority that I have compounded, at which point of time, my lord, under 15(2), the process will stop. The no further adjudication will continue. Very fair, my lord. The adjudication should not continue if a person has compounded that particular contravention. Of course, my lord, it is true that when he is compounding, he acknowledges that he has contravened. Yes. But that is up to him. He takes a risk. He is told that either 3 times is the penalty if you continue to oppose, or you go and compound, you will get a certain different amount. Now kindly come to section 14, which has not yet come to your lordship's, my lord, attention in the course of this hearing. That's all. Does your lordship, my lord, have?
Yes, section 14.
Section 14 your lordship has. Now I am saying that once the section 16 adjudication resulting in a penalty under section 13, once that comes to an end, that penalty has become enforceable in law. The only avenue where it won't be enforced is section 19(1), that is the appeal section. Now see 14, my lord. 14 says that enforcement of the orders of the adjudicating authority subject to the provisions of subsection 2 of section 19, that's the appeal provision. If any person fails to make full payment of the penalty imposed on him under section 13 within a period of 90 days, now my lord, even time limits are there. 90 days from the date on which the notice for payment of such penalty is served on him, he shall be liable to civil imprisonment. Of course, my lord, he is given natural justice there also. He can, my lord, come forward and make his submissions. But after the section 13 process is over, if he doesn't pay within 90 days, that will result in process of civil imprisonment only subject to the appeal provision. What my learned friend wants your lordships to hold is that no, it is not only 19.2 which is available to me after adjudication. Section 15 has again become available to me after adjudication. But then, my lord, that would go in the face of section 14. Section 14 is the clearest indication in the statute that once the adjudication is over, your only option is appeal, otherwise pay up. That's it. Penalty has become final now, subject only to appeal. That is one way of enforcement. The second way of enforcement is 14 capital A, which is a little further down. My lord, I am not troubling your lordship with the rest of 14 because the rest of 14 is an adjudicatory process when it is proposed to hold a person liable to civil imprisonment. That's also a separate process. Full opportunity is to be given there. The other option at that stage is power to recover arrears of penalty in 14 capital A, save as otherwise provided in this act. The adjudicating authority may, by order in writing, authorize an officer of enforcement not below the rank of the assistant director to recover any arrears of penalty from a person who fails to make full payment of penalty imposed on him under section 13 within the period of 90 days. Not only is the scheme clear under the act, each part of the scheme has got time limits. For instance, my lord, even the appeal has a time limit, 45 days. Now, if you don't avail of the appeal remedy in 45 days and you sit tight, then penalty has to be my lord, paid. 90 days are there. He has to pay the penalty or my lord, suffer the consequences of 14 or 14A, 14 capital A. My lord, this, in my respectful submission, is the scheme of this act. You cannot wait for the adjudication to be completed in order to make the compounding application. You make the compounding application, you take the chance, don't make it, then you go for penalty. My lord, this is my lord, the correct interpretation of this act in as far as we are concerned. Now, I will show your lordship, my lord, a few of the rules, if your lordship, my lord, will permit, to show that this is clearly in line with the legislation. But before I do that, I want to bring to your lordship, my lord, the mischief that will be caused if your lordships were to be persuaded to hold that he can make an application for condonation any time after adjudication is over. Because suppose, my lord, a person does not appeal. He just sits tight and doesn't appeal. He doesn't even take out an application for compounding. Then, my lord, this entire time frame, this entire scheme will fall through. By the simple act of non-compliance, he can frustrate this act because he will neither appeal nor will he apply for compounding. Adjudication will remain. Moment any step is taken to recover the penalty or anything, then he will come and say, now I start the compounding process. So, my lord, the whole process will start all over again, 180 days, etc., etc. This is the purpose, my lord, of this submission.
Yes.
Now, if your lordship permits, my lord, a few of the rules. Now, as far as the rules are concerned, there are two rules we may need to consider, my lord. And the reason is that when the process started, the rules were dated 2000. And, my lord, before the process, because the process is not yet concluded as far as my learned friend submissions is concerned, the rules of 2024 has come in. Now, first see the rules of 2000. Your lordship has that, my lord? Your lordship is
don't
looking
know.
at it from the, my learned friend
Compilation.
showed it to your lordship from the compilation.
Yes.
I'll show your lordship from the same compilation.
Wait. No.
Compilation page.
The compounding rules of 2000?
2000. First of all, 2000.
Yes.
Now see, my lord. Before that, my lord, just before that, one small thing. My learned friend is no longer insisting that he is unable to make an application for compounding till the adjudication is over. He is now saying, my lord, that that is not his submission. But previously he was saying that how will I make the application? I don't even know what I am accused of till the adjudication is over. The answer to that is very simple, my lord. There is a show cause notice. There is a complaint and there is a show cause notice. Now the show cause notice, my learned friend has not given in his writ petition. And my lord, because we haven't used an affidavit, my lord, it is not on record. But I can show your lordship the contents of that show cause notice in the office, in the order in original. Right.
In the
So,
final order, it must have
in
been
the order in
mentioned.
original, my lord, at least the substance of it is there.
Yes.
For that purpose, if your lordship just looks at page 85 of the writ petition.
Yes.
So page 85 is, my lord, annexure P7 starts at page 84, which is the order in original passed by Subhash Agarwal, Special Director, Eastern Region. There is a table, name, address, etc., show cause number, all that. Just see the first paragraph. These proceedings, your lordship has that paragraph?
Yes, yes.
These proceedings have their genesis in the show cause notice, so and so, dated 18th November, issued by the adjudicating authority, so and so, to so and so, for the alleged contravention of Section 3A, Section 3B, Section 4 of the Foreign Exchange Management Act 1999 and Clause 3 of Foreign Exchange Management, Borrowing or Regulations of Foreign Exchange, Regulations 2000. So, my lord, all particulars are given to him, my lord. It is for him to decide. My lord, he is the party who has contravened. If he hasn't contravened, he will stand up and say, my records are clean. I have not contravened. These provisions will never apply to me. I'll explain to the adjudicating authority. But if he wishes to compound, then he knows what is the accusation against him. He doesn't have to wait for the adjudication order. In fact, waiting for the adjudication order is taking a chance. He's taking a chance that he will succeed in his adjudication, then he will not compound, and then say that, no, I have failed, now I will compound. That's, my lord, the purpose. So now come back to the rules, my lord, if your lordship doesn't mind. First of all is rules of 2000. 67 of the compilation, my lord, is where it starts. I'll show it from here. And, my lord, 2 or 3 rules here are very illuminating because it is in accordance with the scheme of the Act. Now, who is to do the contravention? That is 4 and 5. So, if it is 3A, then it is the Enforcement Directorate. And if it is anything else, it is the Reserve Bank. Amount will decide which officer of RBI will be doing the compounding. Now, please see, my lord. 6. Rule 6 at page 69. Where any contravention is compounded before the adjudication of any contravention. Lord, could it be clearer? Before the adjudication of any contravention, where a contravention is compounded under section 16, no inquiry shall be held for adjudication of such contravention in relation to such contravention against the person in relation to whom the contravention is so compounded. So this is 15.2 again, but it is even clearer in the rules that before the adjudication, the compounding application should be completed. Contravention should be compounded altogether. Then 7, where the compounding of any contravention is made after making of a complaint under subsection 3 of section 16. Such compounding shall be brought to the authorities noticed in, and on such notice, the person in relation to the contravention so compounded will be discharged. It's a complete scheme, my lord. The Reserve Bank is carrying out the inquiry, the adjudicating process under 16.3. At this stage, he compounds, and then he brings it to the notice of the adjudicating authority, and after that, he is discharged from the original proceedings itself. That is, my lord, the scheme of the act in my respectful submission. Then, my lord, 8 is the procedure, etc., etc. I'm not, my lord, concerned with anything else in this rule. Now, kindly come to the next rule, which is 2024. Actually, my lord, if your lordship sees the master direction, there is one paragraph which throws some light, my lord. Page 73 is the master direction. Now, your lordship knows, my lord, what the Reserve Bank does from time to time is it collects a series of circulars and other directions which are relevant to a particular issue into a master direction in relation to that, and then gives it for the convenience of the banks and everybody else, my lord. So here your lordship will find, it starts at page 73. This takes into account all the master directions relating to compounding of contraventions under FEMA that your lordship has seen from the top. And what they do is that they collect everything up to a particular date. In this case, my lord, this is the final product as of 24th of May 2022. It's a little roundabout, my lord. It says 1st January 2016, but actually it has been updated as on 24th May 2022 and various other dates which are all prior to 2022. So therefore, everything up to 2022 is collected here. Now here, your lordship will find the next page, my lord, is an index of all the chapter headings. And then kindly come to the para 1.3 at page 75, because it gives some idea as to what is the purpose of allowing compounding. 1.3, in terms of the Foreign Exchange Compounding Proceedings Rules 2000, effective from 1st June 2000, RBI is empowered to compound contraventions relating to sections 7, 8, and 9 of the 3rd schedule of the FEMCAT rules, etc. RBI was empowered to compound all the contraventions except 3A with a view to providing comfort to individuals and corporate community by minimizing transaction costs while taking severe view of willful, mala fide and fraudulent transactions. This is the purpose. If you made a mistake, if this is a bona fide situation, I'm giving you that comfort that you don't have to go through this adjudication. You come and compound and that's the end of the matter. You'll be discharged. That's the purpose, my lord, of this. The rest of it, my lord, I'm not troubling your lordship because, as my learned friend said, my lord, it is mostly a reiteration of various parts, my lord, of the rules themselves. Now, the next rule which came was in 2024. And my lord, here whether this is applicable or not is an issue which may arise for consideration. But nonetheless, my lord, I want to be complete here. Has he given that? Yes. My lord, what I'm handing up, my lord, is the gazetted version of the 2024 rules. It is in the compilation. It is in the compilation. Okay. I'm sorry, my lord. I have.
It is there in the compilation.
All right, fine. No problem. No problem. Now, compounding rules of 2024 actually goes one step further and clarifies it beyond any dispute. So I have to go to the internal page. It is there. Oh, it is in the compilation, my lord.
Page 106.
106. 106. Again, after, my lord, laying down which officer will take it up, etc., etc. And then kindly come to 9 at page 109. So these concepts, my lord, which we have been arguing about is collected now. Contraventions not to be compounded in certain cases. No contravention shall be compounded where A, where the amount involved is not quantifiable, or B, where the provisions of section 37A of the Act are applicable. C, where the Director of Enforcement is of the view that the proceeding relates to serious contravention suspected of money laundering, terror financing, or affecting the sovereignty and integrity of the nation. The compounding authority shall not proceed with the matter and shall remit the case to the appropriate adjudicating authority for adjudication contravention under 13. Then D, so that goes to the Director of Enforcement. When the Directorate of Enforcement takes the view that it involves money laundering, terror financing, and matters affecting the sovereignty. Then D, where the adjudicating authority has already passed an order imposing penalty under section 13 of the Act. So what was always there is now explicitly made in the rules itself. E, where the compounding authority is of the view that the contravention requires further investigation by the Directorate of Enforcement to ascertain the amount of contravention under section 30. So section 9 is now clinching the issue. Now section 9, these rules are gazetted on 12th of September 2024. Now his application, the date on which the compounding application will be marked as having been made is 10th of May 2024, because initially made an application, it was returned on the ground that it was incomplete, with liberty to file afresh. He then made the fresh application on 10th of May 2024, and since it is not so important for the purpose of this matter, I am not taking your lordship through the various provisions in the Act, which says that in such a situation, it is the date of the second application which will be the commencement point. Well, the commencement point is important because that's how the time frame under the scheme is gone into. Anyway, it is 10th of May 2024. So it is prior to the gazetting of the 2024 rules. Now, the argument there, because we are arguing that will still apply, 2024 will still apply, because apart from the fact that was the scheme all along, if today the matter has to be gone into, your lordship knows, there is a series of authorities that procedural matters or procedural laws are retrospective in effect, unlike substantive laws which are prospective in effect unless otherwise indicated. I'll just give your lordship one judgment. It's not necessary, it's not very important. I'm just giving one recent judgment on this proposition that procedural laws are retrospective in effect, and that is 2023.
What is the 1 minute? What is the new thing in 24 which was not there in 2000? It is the same thing.
It's not that. It is sometimes things are clarified even just to come to some clarity, and there are some differences when it comes to the officers and all that.
Okay, come. No, but then the petitioners have not placed the 2024 rules.
No, they haven't.
Then why?
I am placing it before your lordship because it helps me. And if it is relevant, then it is patently obvious in these rules that once the adjudication process is over, there cannot be a compounding.
That is there in 2000 also.
Yes, it is implicit there, but it is explicit here.
All right.
So that is the. We'll just hand it up, your lordship may just note para 33. I'm not placing the judgment in any detail if that question comes up, because in the writ petition, my learned friend was even challenging the rules, saying that you cannot use the rules to cut down the parent act.
That has not been submitted.
Exactly, that has not been submitted. So, I'll end, by saying only this, that now look at the dates once, how it happened. The show cause notice is 18th of November 2022. The first compounding application was made on 20th of January 2023.
Yes.
So he made an application before the process was over. That was his understanding also. All right. Then, the first compounding application was returned on 8th of January 2024 with liberty to file fresh compounding application. This is just mistakes are there. That's all. Then, my lord, he did not file, my lord, the second application till 10th of May 2024. There's a gap of, my lord, 4 months, even though, my lord, he knows that there are time limits running with this scheme. And there, my lord, he has...
But then 1 minute, 20th of January 23, the first application is made.
Right.
And you reply, in
Yes.
fact, you return it on 8th of January 24. It's nearly a year. In between
There was correspondence.
There was some correspondence in between also.
All right.
It was effective and
31st March and 4th of April 2023. My lord, there was some correspondence because this is something which can be rectified by the other side. There was some problem with the application, details had not been given, that they can rectify. That is not the problem now. So therefore, my lord, after they made the compounding application, on 28th of March 2024, the adjudication order was already passed before he makes the fresh compounding application. That is 10th of May 2024. So, my lord, basically, my lord, he is waiting. And then he make the application, even though he doesn't actually know that the adjudication order has come because there is no formal communication of this order at that point of time. Now, 11th of September 2024 is the impugned order of RBI. That is, fresh compounding application is rejected on the ground that the adjudicating order has already been passed. And now comes the writ petition, my lord. And then when the demand notice comes, there's a second writ petition. So, my lord, what is to be done now? Reopen the whole process, which came to an end on 28th of March 2024 with no appeal, no application for compounding at that stage, and reopen the whole thing, my lord, and start all over again. This is, my lord, the purpose of this writ petition. So, my lord, in my respectful submission, my lord, the scheme has not, my lord, been properly presented by my learned friend, and it is adjudication. If you allow the adjudication to complete itself, you're taking a risk. Anybody is entitled to take that risk. But if you don't wish to take the risk, then you apply for compounding. There must be some, my lord, there must be some incentive for them to go for compounding also. If this is what it is, that I now know that I have to pay 10 crores fine, therefore I will go for a compounding, then, my lord, that defeats the whole process. My lord, the last thing is, my lord, since we are not using an affidavit, the allegations in the writ petition may not be taken to be admitted by.
Do you wish to use an affidavit? Because point of law that is being...
Because this is a legal issue, no doubt. No, we don't.
Only the pure question.
Yes,
we don't wish to use. We don't wish to use. Only thing is, my lord, that must not be taken as a indication that
admission on your part.
Accepted everything, because there are certain paragraphs which say that substantively we are denying that there is any contravention. Now, if I don't say no to that, then later on my learned friend might come and say it in some other process.
I'm only arguing a question of law.
Yeah, that's good. That's fine. There's no difficulty. Because my learned friend is arguing a question of law, it is not necessary for us to use an affidavit. But, my lord, your lordship will only, my lord, protect us by saying that this does not, that it won't be an admission of fact.
My lord, appearing on behalf of the Enforcement Directorate on the last occasion, I pointed out before your lordship, whatever I pointed out, my senior appearing on behalf of RBI today made those submissions. So I will not be reiterating those submissions. I will only add some points after adopting his arguments. Now, my lord, kindly take, because my lord has gone through in this matter only through section 15 at least for 5 times. One more time for my satisfaction. Because as my learned senior friends have correctly pointed out, that is the genesis of this matter. Because the only question of law, whether after adjudication, compounding is permissible. Any contravention under section 13 may on an application made by the person committing such contravention be compounded within 180 days from the date of receipt of application by the Directorate of Enforcement or such other officer of Directorate of Enforcement or officer of Reserve Bank as may be authorized in this behalf by the central government. And will kindly mark next few words in such manner as may be prescribed. So this section 15 is always subject to the manner prescribed. So tomorrow, nobody can come before your lordship and say that the rule cannot prescribe which is not in the section. So it is subject to the rule. Now kindly take section 46. Now I'm just adding to what my senior friend said. Section 46, power to make rules. Your lordship is there?
Yes.
The central government may by notification make rules to carry out the provisions of this act without prejudice to the generality of the foregoing power. So subsection 1 is a general power. Without prejudice to the generality of the foregoing power, such rules may provide for, kindly take B, the manner in which the contravention may be compounded under subsection 1 of section 15. So this rule, now kindly take that rule of 2000. At the top, your lordship will find that this is made on the power of section 46, read with 15.1 by the central government. Now your lordship has seen those rules. So rule 4, power of Reserve Bank. Rule 5, power of ED. Rule 6 and 7, I submitted on the last occasion. Probably 6 and 7 are the only two provisions, rule, which shows that when the compounding can be done. First one is section 16 is in commensurate to 16.1, subsection 1, and section rule 7 is in commensurate to section 16.3. Now your lordship will kindly see sub rule 4 of rule 4. Because it is the case of my learned friend senior that they are falling under rule 4. Every application for compounding any contravention under this rule shall be made in form to the Reserve Bank of India, such and such. So the form is important. The same provision your lordship will find subsection 4 of section rule 5, sub rule 4. Now kindly take the form appended to the rule and kindly take serial number 4. Well, a different interpretation is trying to be portrayed before your lordship, knowing fully well what is the law. Kindly take serial number 4. Name of the adjudicating authority before whom the case is pending. So it cannot be that adjudication is over, then I can fill up this form. Now kindly take the writ petition. First, your lordship take page 71. Petitioner before your lordship was all along aware what is the law. 71 is his first application for compounding. Kindly take serial number 4. Name of the adjudicator, same form. He had made it, Special Director ED. Now this is rejected. On the ground, kindly take. That is also important. Page 80. Your lordship was asking that why there is a gap of 1 year. I tell your lordship, this is actually the third round of litigation with connection to this case. During this 1 year, petitioner was pursuing his remedy before this honorable court, which he is entitled to, saying that the complaint and the opinion formed by the adjudicating authority on that issuing show cause notice is bad in law, which was rejected. They preferred an appeal, intra-court appeal, which was rejected when the honorable division bench found that the adjudicating authority has acted actually in accordance with law of rule section 16.3 and 16.1.
Are those orders here?
No, they have not. I'm carrying, if your lordship want, I can.
All right.
First, kindly come to say page 80 then. Why it was rejected or returned, this first application. He is saying repeatedly that committing, the word committing, the person committing the contravention. So I cannot know as I have committed unless there is adjudication. Then why this first application? How this first application? You are not committing. You are not in knowledge. Then kindly see page 80. The rejection. Reason of rejection or return. Para 2. Due to the above. I will read from para 1. The applicant is in compounding application had mentioned that the portfolio account drew advances on various occasions. However, only the amount pertaining to peak advance US dollar 9,57,304 has been mentioned in the application. Due to the above, there is lack of clarity, kindly mark, on the number of advances availed, their respective total amount, and the dates on which these advances were availed. In view of this, the total amount of advances availed and period of these advances cannot be ascertained, thereby leading to difficulty in ascertaining the amount and period of contravention. In view of the above, the compounding application of Sri Sanjay Jhunjhunwala is being returned. But the next sentence, you are at liberty to file afresh, is always general. This does not mean that his first application was bona fide or rejected on technicality. No, it was not rejected on technicality. It was returned because the rest email correspondences, his replies are there. I'm not going through that. Those shows that time to time RBI asked him, clarify, give the details, clarify, give the details. He has given something, something not. Ultimately, RBI returned it because from the complete set of the application, RBI is duty bound, as my senior friend was indicating. All the work acts are time bound. RBI was also duty bound to complete it within 180 days from the last complete set of the document. So RBI has no other option. RBI said there is no clarity, hence it is returned. So that was the reason. This was prior to that. Now what happened after this? After this, he did not make the fresh application. He came back and joined the adjudication proceeding. Just to refresh your lordship, page 84, the adjudication order starts. Your lordship will find he participated. The date of participations are very important because this was on by RBI 8 January 2024. Correct? Now, kindly take page 100.
Which page? 8 January you showed me?
My lord, page 80, the email of the RBI at the top left-hand side. The date your lordship will find 8 January 2024.
Date of return.
Return. Right. Now your lordship kindly come to page 100. That is internal page 17 of the order. Paragraph 3.1. But kindly take first sentence. In reply to the show cause notice, Sanjay Jhunjhunwala by his letter dated 4th January 2023. That is when his application was pending, or this application before RBI was pending. He took time up to 20 January 2023. Then on 20 January 2023, he submitted his reply. Correct? Now, reply I am not going into. Your lordship will find that every paragraph he has said that there is no contravention on my part. It is his right to say. Now, kindly take the last paragraph that is at page 106N. 106N, last sentence. He submitted a copy of his compounding application without annexure and compounding fees. So, as my learned friend was showing, that if Rule 7 says, once he goes for compounding, he is to intimate the adjudicating authority. He was aware of, and he intimated. Then, kindly take the next page. Paragraph 3.4. An email dated 26/4/2023 received that he is such and such having some difficulty, patient of such and such. He prayed for time, hearing after 8 May 2023. Then next paragraph. Personal hearing was fixed on 10th May 2023. His advocate gave letter that High Court proceeding is pending. Kindly see. Then paragraph 3.7, letter dated 12th May, High Court Division Bench. Detail. Then para 3.8, 3.9, I am skipping 3.10. He appeared before the adjudicating authority on 9th June 2023. Submitted written submission. So reply once, one reply, then number 2, this is written submission. Then kindly take next page 109. Para 3.16. Sanjay Jhunjhunwala again appeared on 28th June 2023 and submitted written submission dated 28/6. This is the third written submission. Then page 110, para 3.18. Sanjay Jhunjhunwala made his further submission with a letter dated 3rd July 2023. So there were 3 written submissions, 1 reply, total 4, up to 3rd July 2023, when his compounding application was pending. The first compounding application was pending before the Reserve Bank of India. So he was all along aware that I have made a compounding application. Parallelly, he is participating in the adjudication proceeding since there is till date no compounding. He stands in compounding application and in adjudication are completely and diametrically opposite. Now, this order passed after considering all this, where the finding starts from page 111 and ends at page 139. Finding that there were contraventions for which he is liable for penalty, total borrowing of rupees 202.46 crore was contravention, above 3.46 crore. So penalty of 10 crore was imposed. Now once it is imposed, my learned senior friend has already showed your lordship, section 14 will come into operation. Section 14 says, subject to section 19. Mean 45 days you have the time to file appeal, subject to a condonation period also. That is why legislature at their wisdom made 45 plus further 45. Reasonably for condonation if people are at delay. So after 90 days, you will go for recovery. We have gone for that in the month of January 2025. Only after that he came before this honorable court in this petition. Your lordship will find that he made an earlier petition. Now, this scheme of 2024, rule of 2024, your lordship was asking, I was hearing, that what is the difference? Your lordship, the difference is rule 9. Earlier rule 9 and now rule 9, if your lordship takes...
Is it relevant in this case? Yes. Is rule 9 relevant?
Yes, relevant. Rule 9 is relevant after 2024. After 2024 rule 9 became relevant. Rule 9B, D is now crystal clear. No contravention shall be compounded where the adjudicating authority has already passed an order imposing penalty under section 30.
This is what it has been said, that it makes it more explicit.
Yes, this has made, since it is procedural, it has always has the retrospective effect and it makes more clear because the scope, your lordship can see section 15, section 13 contravention, section 3 contravention, section 16 adjudication, section 15 compounding comes prior to the adjudication and read with rule 6, rule 7 of the compounding rules which were framed in terms of the power granted under section 46, read with 15.1. It makes it clear that you can avail either way. Either you go for compounding by saying, yes, there is a contravention on my part, I want to compound it. Or you participate in the adjudication by saying there is no contravention on my part. He availed both. And he waited. The first one rejected on the ground of non-clarity. He waited for 5 months. He waited the adjudication to get over. He, in his own words, he said, had there been a 10 lakh rupees penalty, I would not have gone for compounding because my compounding fees would be around 21 lakh under that matrix. Since it is 10 crore, now I am in compounding. That cannot be the law. That cannot be the intention of the legislation. Then the appeal 45 and section 14 recovery 90 days time and adjudication all would become redundant. Nothing is required. Everybody will go for whenever. I have not gone to appeal. There is no section 17 or 19 appeal. So after 3 years, I can go for the compounding. There is no time limit. And after adjudication, I can go for compounding on any date. I have not filed any appeal. Suddenly, after 3 years, when I've been chased for recovery or civil imprisonment, then I woke up. I made an application for compounding. See, that cannot be the law. And the format, my lord, it was interesting. I missed it. I showed your lordship the first application form. My lord, kindly take for 1 minute. Just see the second form. Page 141. In the first one, serial number 4, he has said before whom it is pending, before the special director. Now kindly take page 141. This is the second application after adjudication everything. Right. Kindly take serial number 4. Now the format is changed over here. Name of the adjudicating authority before whom the case is pending. This is as per the form. Now his answer. The case of the applicant has already been decided by Land and Special Director Eastern Region.
So he is aware.
He is always aware that it has to be done before whom it is pending. If it is concluded, it cannot be done. So that is our case all about. So my humble submission is this at the end, that the RBI has rightly rejected his application after the adjudication order, has not allowed the compounding, and the Respondent Enforcement Directorate has rightly issued the recovery notice. In fact, it is a notice which is in consonance to section 14, subsection 2. Your Lordship was seeing section 14.1. 2 says no such recovery or action will be taken unless there is a notice. So this is the notice under section 14, subsection 2, and which gives even an option at serial number 3, if your Lordship takes it for once, page 165. No, sorry, it's not 165. 165 is returned, 166.
Demand notice.
Demand notice. Now, therefore, he is hereby given an opportunity. Number 1, to pay outstanding within 7 days. Number 3, to submit copy of order of appellate authority waiving the requirement of pre-deposit. Because the rule is, if your Lordship takes section 19, when you file appeal, you have to deposit the entire penalty. Second proviso says that in a hardship, if a case of hardship is made out and an application is made, tribunal has the power to dispense with either whole or part of the pre-deposit. So that was our question. And this question is on the basis of adjudication order of March 2024. Section 14 says 90 days. It is well beyond 90 days in January 2025. So this is very well maintainable and is required to be upheld by this honorable court.
Your reply, please.
Yes. My lady, we are concerned with the case. Is a compounding allowed after adjudication order? I did not argue one way or other whether compounding is allowed before an adjudication order. That was not my submission at all. Your ladyship may see your notes. I have not argued that. Obviously, if a show cause notice is issued to me, I admit the offense. There's nothing to adjudicate. I'm admitting the offense and I have to pay the compounding if I want to pay the compounding. Otherwise, an order will follow. You have admitted the offense and pay the penalty. Therefore, we are not dealing with the case which my learned friend, Mr. Gupta, set up as a straw man. What about a case where he files an application before adjudication? We are not dealing with that case. That doesn't arise. But since he has raised that issue, I'll state my view. My submission is, when a show cause notice is issued, you can apply for compounding, but you have to admit the offense. There's no more adjudication because you are admitting you have committed the offense. If you are committing the offense, you will have to either face an adjudication order or face a compounding. But there is a difficulty there. If the show cause notice issue includes 3A and other provisions, who do you apply to compounding? If 3A is involved, 3A RBI cannot compound. All other sections RBI can compound. ED can only compound 3A. Please see the section.
But then your application for compounding was pending before the competent authority.
I'm not saying I applied, but my learned friend graciously said, you can make an application by mistake without giving enough. That was returned. It was not rejected. It was returned with fresh liberty to file an application.
And you did it.
I did it.
Yes.
I'm not saying that. So the first application is not relevant before your ladyship.
Very well.
First
Second
application. I'm only want to keep out of the way an irrelevant matter, or I'll put it this way, not relevant matter. What is the validity of the first application does not arise before your lordship. I am saying after adjudication order, I'm entitled to file an application for compounding.
Very well. So you take it that prior to an adjudication order being passed, you could have filed an application, but at the same time,
I have to admit the offense.
You are admitting.
No. In this case, I have not admitted 3A. In that application, I admitted only the regulation 4, and therefore I applied to the RBI. If I'm admitting 3A, I'll have to apply for compounding to the Enforcement Directorate. I hope I'm making myself clear.
Yes.
Because 3A can only be compounded by the Enforcement Directorate. Please see section page 68. Power of Reserve Bank to compound contraventions. If any person contravenes, page 68, any provisions of FEMA except clause A, etc., the Assistant General Manager, Deputy General Manager, and Chief General Manager.
But the show cause notice that was served upon you clearly mentioned
3A and other provisions. Kindly see the show cause notice. It is not annexed, but it is in the impugned order.
Impugned order
says the provisions.
Yes.
Kindly see the impugned order. At page 84, it starts. And at
5 is the show cause.
No, no, this is not impugned order. This is the adjudication order. I said impugned. I'm sorry. Adjudication order. Now, please see 85, nature of contravention. Section 3A, 3B, and 4. Clause 3 of Foreign Exchange, etc. regulations, and Section 6 of the Foreign Exchange Management Act. So both are there. 3A and other provisions and other regulations are there. I admitted only to the regulations. And I applied for compounding to the RBI because 3A I have not admitted. If I had admitted 3A, I would have had to file compounding to the Enforcement Directorate. Therefore, I'm saying for this case, it's not necessary for your lordship to decide whether I can apply for compounding before adjudication. That is not the issue. When that case arises, your lordship will decide. What about a composite show cause notice where 2 compounding authorities are involved? Who do I apply to? Therefore, my respectful submission is your ladyship should not go into that question because that doesn't arise in this case. Then you'll have to decide who is the compounding authority for the first application. 3A, 3B, 4 is all there. Kindly now see section of the Act, compounding authority. Section 4. Rule 5. Rule 5 at page 68. Well, that's unnecessary to decide here. The compounding authority, no. Okay. Rule 4, page 68, rule 4.
Yes.
Your ladyship may take it from me, and I don't think my friend will dispute it. For 3A, the compounding authority is only the Enforcement Directorate.
Yes.
For all other provisions, the compounding authority is the RBI. In this case, the show cause notice included both. But I applied only for compounding to the RBI. Therefore, whether that application was valid or not does not arise in this case. The RBI, for good or bad reason, returned it and say you file a fresh compounding application. So the validity of that application does not arise for decision in this case. A court should decide only matters that are relevant to the decision. If you go into the first compounding application, whether it was maintainable or not, you will face this conundrum. Who is the compounding authority? I applied only to the RBI. I didn't apply to the ED. So who will compound 3A? I have not, besides, that is one ground. Second is I have not admitted 3A. I have not even admitted 3B. I have not admitted section 4. I have only admitted regulation 4. Therefore, RBI, according to me, said this is an incorrect application, incomplete application. There are not enough material is being given. I'm returning this application, not rejecting it. My learned friend who appeared for the ED says it was rejected. It was not rejected. Returning the application, you make a fresh application. Whoever want to make an application, you apply afresh. Correctly, RBI said, I can't deal with this application because it's incomplete. Therefore, keep that chapter aside. Doesn't arise for decision in this case. As I've been saying from day one and today, the only question that arises is my learned friends correctly summarized it, and I also correctly summarized it. After an adjudication order, is a compounding application maintainable? And I'm requesting respectfully your ladyship to decide that question. So that will decide the rival cases. If we go into the first application, all kinds of conundrums will arise. And there are no pleadings on that. If nobody has pleaded that case, I have not pleaded that case. I have not said it's valid. They have not said it's invalid. Nobody has said RBI was right or wrong. Therefore, please don't go into that question. The only question is my application made on 10/5/24 after the adjudication order of 28/3/24 maintainable or not? That your lordship may certainly decide. Now, the first point is the scheme of the act. My learned friend said it is not in the order in which it should be read. Now, please see that. It's perfectly in order. That I'm replying to his arguments. I'm not repeating my arguments. It's perfectly in order. And the order is very clear. Now, please see the act, page 15 of the compilation. If any person contravenes any provision of this act, he shall, upon adjudication, be liable to a penalty. So somebody must adjudicate it. It's a different matter for admitted. It's not a case of admission. If any person contravenes any provision of the act, upon adjudication be liable to a penalty. This is section 13. Now kindly see section 14. Subject to the provisions of subsection 2 of 19, which is appeal, if any person makes to pay full payment of the penalty within a period of 90 days, he shall be liable to civil. So the enforcement of the order is 90 days. So you pass an order, enforce it on 90th day. The appeal provision is 45 days. Both 17 and 19 is 45 days. Therefore, an adjudication order is passed. On 45 days, you will know whether an appeal has been filed, either under 17 or 19. And an interim order is passed or not. Then on the 90th day, the order will be enforced. The sequence is quite clear. Now comes 15. There's no jumbling. It is deliberately drafted this way. Now comes 15. Adjudication order, enforcement in 90 days. Any contravention under section 13 may, on an application made by the person committing such contravention. I can't decide for myself whether I commit such a contravention. If I decide for myself I am committing contravention, why would I go through an adjudication? I'll, in the show cause notice, I'll say, yes, I'm sorry. No, please forgive me or please impose a small penalty. Any person, any contravention made by the person committing such contravention be compounded within 180 days. Please see, appeal is 45 days. Enforcement of order is 90 days. Compounding application is 180 days. It's not, mindlessly they have given this time limit. There is a sequence. 45 days you file an appeal. Otherwise, in 90 days it will be enforced. You can compound it within 180 days. No, I'm coming to that. Now, what my learned friend did not refer to or read or contradict, he did not read Rule 11 at all. I was waiting until the end that he will read Rule 11. He did not read Rule 11 deliberately. Advisedly. I'm not saying deliberately. I apologize. Advisedly, he did not read Rule 11 and Instruction 6.4. Now, this is the act These are the rules, and then there are instructions. Now please see Rule 11, 45 days for appeal, 90 days for enforcement, 180 days for compounding. Now please see Rule 11, which is at page
70.
70. He did not read. I was waiting for him to read Rule 11 and explain it. He did not read because it's dead against him. Rule 11 at 70. No contravention shall be compounded if an appeal has been filed under Section 17. If you file an appeal, no contravention shall be compounded. If you don't file an appeal, it's compoundable under the 13, 14, and 14, 15, and 16, 14, 13, 14, 15 sequence. Now, how does he explain no contravention shall be compounded if an appeal has been filed under Section 17? Why did the rule-making authority did not say no contravention shall be compounded after an adjudication order is passed? Why did they not say that? They said it in 2024. They've tightened the rule. He said it's clarificatory. I'll show the difference between 2000 rule and 2024 is difference between chalk and cheese. They've tightened the rule in 2024. And yesterday, the Honorable Finance Minister announced they're going to liberalize the rules again. 2020 to 2024, they've tightened the rule. I'll show significant differences. This rule could have said no contravention shall be compounded if an adjudication order has been passed. He is reading this rule to mean, he did not read the rule to your ladyship, but he is impliedly reading the rule to mean no contravention shall be compounded if an adjudication order has been passed. No, it doesn't say so. No contravention shall be compounded if an appeal has been filed. Appeal is within 45 days. If an appeal has been filed, no compounding. Then 90 days enforcement, 180 days compounding. That is the scheme. Now see the instructions under 6.4. How did the RBI understand this rule? Instructions are at page
73.
73 it starts. The relevant rule is at 81. This is much later than the rule. This is updated up to 2016. How did the RBI understand it up to 2016? The rule was in 2000. RBI understood it in up to 2016 in 6.4. In case, anything else? In case where adjudication has been done by the Directorate of Enforcement and an appeal has been filed under Section 17 or 19, no contravention can be compounded in terms of Rule 11. The applicant shall confirm in the undertaking required to be furnished, along with the compounding application, that they have not filed an appeal. This paragraph becomes meaningless if your ladyship accepts his argument. I have to file a compounding application and say, I have not filed an appeal, and therefore please compound it. It can only be after that it says where adjudication has been done and an appeal has been filed, no compounding. I have to, in the compounding application, say, I have not filed an appeal. What does it mean? Why is paragraph 6.4 there? RBI's understanding up to 2016. Why does the RBI say that you can file a compounding application, you will have to give an undertaking you have not filed an appeal, and then I will compound, I'll entertain the application. What is the meaning of 6.4? He did not refer to Rule 11. He did not refer to paragraph 6.4. And quite rightly, because it's dead against his case, totally against his case. It contemplates an adjudication. It contemplates an appeal. It contemplates a situation where appeal is not filed. It contemplates an undertaking to the effect, I have not filed an appeal. And it contemplates compounding. the 5 parts of 6.4, an adjudication order, an appeal is possible, an appeal is not being filed, an undertaking is given, I have not filed an appeal, and then compounding is allowed. This is completely supports my case. Rule 11, 2000 and 2016 RBI's understanding of the rule and the section. Now immediately go to 2024 rules. They have tightened the rule. My learned friend glossed over by saying it's clarification. It is tightening the rule. It is a much stricter rule. For example, 1. Rule 9 has no counterpart in the 2000 rule. Rule 9 of 2024 has no counterpart provision in 2000. 2000, all offenses can be compounded. When your lordship will decide, that's a different matter. But Rule 9 excludes some offenses for compounding. Please see 109. This is not clarificatory, this is tightening. No contravention shall be compounded. A, B, C, D, E. And then among them, D is the new tightening. Earlier, it was no compounding after an appeal has been filed. Now it is no compounding where an adjudication order has been passed. It's very different. It's not clarificatory. It is the exact opposite. That is chalk and this is cheese. No compounding earlier after an appeal has been filed. Now there's no compounding after an adjudication order has been passed. Number 1. Number 2, please see Rule 14, which my learned friend did not refer to. Any compounding application pending before the compounding authority on the date of commencement of these rules shall be governed by the rules of 2000. It's not as though it's clarificatory. It supersedes that rule and says that rule will apply until these rules come into force. And when do these rules come into force? Please see page 106. These rules come into force on 12th September. In exercise of powers conferred in supersession of the compounding rules 2000, except as respects things done or omitted to be done before such supersession, the central government hereby makes the following rules. These rules may be called. They shall come into force on the date of their publication in the official gazette. They come into force only on 12th September. My order was passed on 11th September. My application was pending earlier. If the application is revived, it will be governed by the old rules. So this rule is not clarificatory. This rule is diametrically opposite to the 2000 rule. The 2000 rule 11 categorically said no compounding after an appeal has been filed. The 2024 rule says no compounding after an adjudication order has been filed. There are two different stages, adjudication order and the appeal. Earlier rule said after appeal is filed, no compounding. The new rule says after adjudication order, no appeal. This is the rule. The RBI has passed an order on 11th September. This rule came on only 12th September. I don't know. But it assumes that no compounding is entertainable after adjudication, whereas that comes into force on 12th September. No compounding is available after appeal is the old rule. I have not filed an appeal. And please keep 45 days for appeal, 90 days for enforcement, and 180 days for compounding. The sequence is quite clear. There is no jumbling up of anything. There's no misarrangement of the sections. Now, I'll finish in 5 minutes. My submission is, in this case, forget the earlier application. It was defective, no material. I may have filed it to one authority, whereas 3A It is not the authority. Ignore that. Ignore that because the RBI has ignored it. RBI has ignored it. My learned friends can't say you must rely upon it. RBI has ignored it, and not only RBI has ignored it, has said you can file a fresh compounding application. Why did they say this is to be erased and you can file a fresh compounding application? That's what the RBI said. Now, before I filed the application, the adjudication order came. I'm not denying that. But I gave you reasons why I can wait for an adjudication order. One, I'm only repeating myself, I'm reiterating my submission. One, whether I'm guilty or not. If I'm not guilty, then why should I compound? Therefore, whether I'm found guilty or not. Number two, whether I'm guilty of 3A or any other provision. Because then the compounding will go to different authorities. I don't know who to compound to. Three, and my learned friend, what's his name? My learned friend said, I'm sorry, I didn't know you. My learned friend said, you're waiting for the penalty order. Of course, I'm entitled to wait for the penalty order. If the penalty order is 1 lakh, why should I appeal or compound? The penalty order is 10 crore. I'm entitled to wait. That is why 180 days is given. Therefore, I'm waiting for the order. I examine the order and I decide whether I should file an appeal within 45 days or I should file a compounding within 180 days. I know that 90 days enforcement will start. So I have a 45-day window for filing an appeal. I have a 180-day window for filing compounding. In between, 90th day enforcement will happen. Therefore, when the adjudication order is passed on 28/3, within 45 days, without filing an appeal, I filed a compound. Please see the date, 28/3 and 10/5. So I filed it, deliberately filed it, because this one, he has exonerated me of 3A and 3B. Therefore, I know which is the compounding authority. There is certainty about the compounding authority. There is no ambiguity about the compounding authority. I know RBI is the compounding authority. One, I know that under the matrix, I am liable to pay approximately 21 lakhs. I know that the penalty is 10 crore, and I decide in consultation with my lawyers whether I should file an appeal, which it will go on, appeal, high court, etc., or I should compound it. I decide to compound it. Now, you can pass an order on compounding on merits, whatever order RBI wants to pass, but it cannot return it on the ground. It is not maintainable. That is the question your lordship is requested to decide. Is it maintainable or not? What else? Therefore, my submission is my application filed within 45 days of the adjudication order, after the adjudication order, without filing an appeal, is perfectly maintainable under the Act, section 15, read with Rule 11, read with Instruction 6.4. Section 15, read with Rule 11, read with Section 15.4. If your lordship, if your ladyship quashes the order, the old rules will apply, because the new rules will apply only to fresh proceedings. Old rules will apply, and the RBI can pass an order on merits. It may compound, it may refuse to compound for whatever reason.
Very well.
Those are my submissions.
Right. I will require a written notes of argument from.
Yeah.
Again.
No, that's not correct, my lord. This is all.
How is it possible?
RBI's order is being challenged. RBI's order is being challenged. What is this? What is new?
The lordship will see. I'm just finishing. The lordship will
No, you have finished already.
If he argues, then I'll have
Then
the right
there'll
to
be
reply.
no end to it.
There'll be no end to it.
It was not reviewed earlier, so I have no scope to review.
Whatever you what is it? Why should I roll the rules to Please don't raise your voice. Please don't raise your voice.
Please file your written notes of argument. Very short,
prospective.
very short, not more than a page or two.
Yes.
Not
Two
more
pages,
than that.
2 pages.
Maximum, not more than that.
Millard,
2 pages is.
only one error, Millard. Section 15 starting point of 180 days is not the same as the starting point of 45 days or 90 days. They are two different things altogether. My learned friends.
And there is no precedent on this line.
There's no precedent. If there's a your lordship will
I could
lay
have
down
been
the
saved a lot of time.
That is why I'm saying, please confine it to this question of law
Yes,
and then decide the question of law. Interim
How
relief.
soon, how soon can you file your written notes?
1 week, Millard.
No, we can file it in 2 days.
All right.
Whatever time you give him,
Yes,
please
yes.
give me.
Yes.
By this week, today is Wednesday.
No, how
week.
much do you want?
He
1 week.
requires
Jaideep. 1 week.
One
My friend Jaideep wants 1 week. Please give us all 1 week.
Yes.
All right.
Next Tuesday.
I'll give you till 14th.
Yeah.
So
What is-
everyone is happy.
Yes.
The interim
Based-
order you.
I'll extend it. I'll
Interim-
extend it. I will extend it.
There is the
obliged.
interim orders that they will not take any steps.
Yeah, that's all.
They are expected not to take steps.
No, no. You file it by 14th. Please come.
Very good.
Wait. What required? No. Yes, to be mentioned for filing the written notes of argument. You are not here. Just filing, you can get it done by somebody. Yes. Your presence may not be required. It's yes.
Within 180 days, I can file an application and get it decided. 45
Hearing
days.
concluded on the point of law.
The window is 180 days. This window is
Stop
45
liberty to
days.
the parties
That
to
window
file
is
written notes of argument on 14th February 2025
30.
when the matter will appear in the list under the heading to be mentioned.
We'll put it.
Stop. The interim order that is subsisting is extended
That I
till
agree. We only asked you a question of law.
28th of February 2025 or until further order, whichever is earlier. Let it come up on the 14th, file
Obliged.
your written notes, and then the next date can be fixed. An interim order has been extended till the end of February.
Deeply obliged.
Lordship.
জানাবো এটাকে staple
Milord, may I mention one matter, Milord? Milord, may I mention?
আচ্ছা
Milord,
বলা হয়েছে তো আপনাদের সবাইকে But this is not the time to mention.
On 31st, your lordship passed an order, Milord. I was sitting from 10:30 to 3:45, Milord.
This
Milord,
is
order
not the
was
time to
passed,
mention.
Milord.
Please
Milord, order was passed, Milord. My name is not there, Milord.
give your it will appear for correction. Give the number. Call the list, please.
Not signed, Milord. The order is not signed, Milord. I came to know, Milord.
Then how did you know your name is not there if the order is not signed?
There, Milord.
I do not know. I have to check up. Can't say. Item 2. Give.
Milord,
I appear for the
we could wait for 10 minutes.
No, 10 minutes to go to my chamber and come back. It will take 20 minutes. And I have been informed that today there is an early rising. So it's better I finish it off and then get up.
My lord, I appear for the petitioner, my lord. This is a very short matter. The long and
Who is the official respondent?
my lord, there are several.
Several.
Starting with the fire department, lordship. Lordship will see the array of parties.
Pollution
There
is
is-
there. I can see Bidhannagar Municipal Corporation and the state.
Pollution
Control Board, Lordship.
Arjun Rai Mukherjee is applying for the Pollution Control Board, Your Lordship. Your Lordship, his father expired just last week, Your Lordship. Therefore, I'm
My
pretty
lord-
time in regard.
My lord, may
Pollution very important.
for today's purpose, Lordship, only respond number 6 would be sufficient. Because
Department of Fire, state possibly is here.
Lordship, I am for the state.
Ready with the instruction from the fire department.
Lordship, I have got the instruction from the police department, Lordship.
Police not required now. Possibly fire.
Lordship, may I just in very short, I'll ask what the interim order I'm asking for. Lordship, I'm the owner of a house, aged lady, several ailments. My husband is also aged with several chronic illnesses. There is a trespass on my ground floor. I am not getting into the issue of the legality of his occupation because that is not the subject matter of this proceeding. The issue is that they've been running a sweet shop with a manufacturing facility on my ground floor, which they have started recently, which is causing a lot of pollution. Not only that, they do not have any rent agreement, nothing, no document, but this entire business with manufacturing activity causing immense pollution, sound, air, on all several aspects without obtaining any license or clearance from any authority. Now, I have made complaints before the concerned municipality. I have complained before the Pollution Control Board, the fire department, the GST authorities, everyone. Action has not been taken. It is only with respect to the fire department, Lordship. I had made a complaint. Fire department had called me for a hearing. I went, and then a direction has been passed by the fire authorities that this business should stop because they do not have any fire license. My lord, kindly sees page 87 of my writ petition. And this is not the first occasion, this is the second occasion. Page 87, Lordship will kindly see. There was a previous notice directing him to stop, but it was not adhered to. The problem is that the person who's running this establishment is politically powerful, which is why no police authorities are taking any action.
Let me see the police report once.
I am for the private person.
I'll hear you. Don't worry. Yes.
My lord, on the previous occasion, no one took any steps. Despite a similar notice being given, the police authorities did not act. On the contrary, they came and threatened me for lodging this complaint. Now, Lordship, I was compelled to file this writ petition. After I filed the writ petition, my harassment has increased tenfold. Even as late as last night, before this matter was to be moved, and after we served them notice that we had mentioned the matter and it would be listed today, the police came to threaten me last night. We have video footage, etc. We'll submit it in our affidavit in reply. The simple order, Lordship, I'm seeking today is if Lordship kindly directs the authorities to implement this order for now, as far as the fire department is concerned, and as far as the other respondents are concerned, if Lordship kindly directs them to file reports stating whether they have the licenses or not, even if they've applied, what is the status?
All right. Yes.
2 minutes. Since 1978, before he got the property from his predecessor in interest by of deed of gift, I am doing the business, not only the sweetmeat shop, but we are preparing the sweets over there. They reconstructed, they given the property, given me space for running the shop as well as the sweetmeat my manufacturing process. Entire submission.
Show me your fire license, please.
Yes, I'm deeply obliged. My lord, see the compilation. First shows my trade license. The second shows, first document is my trade license.
May we have a copy, sir, please?
Certainly.
1 minute. This is the e-trade license.
Yes.
September date of issuance is September 24.
Yes, Mark, kindly see the last certificate enlistment will be enforced until 30th.
Did you serve upon the corporation?
Malad, I've served.
Oh, I didn't see you. You joined in just now. You were there. I missed you. Sorry.
Kindly see the second page. That is the fire license.
Second page is the fire license. A license is granted to Matara Mishtanno Bhandar.
Yes, my lord.
License number 10. As where
Simple sweet meat shop where, my lord, the sweets are being prepared and no extra heat is generated, nothing of factory is, my lord, the nature is being done. It's a ploy to evict me from the property.
Listen, here there is an order of the fire authority.
That is not the order, my lord.
Section 35 notice is there to stop.
That is not the authority who has, my lord.
That is a different thing.
This
Have
is
you
the
challenged
license.
the order?
I am holding the license, my lord.
Did you challenge the order which he seeks implementation of?
My lord will adjudicate it. My lord will adjudicate
Why?
it. My lord can send it to the authority also.
Why? For
But
what
the
purpose?
time
He
being-
seeks implementation and I will go and adjudicate the
the
validity.
time being, I am holding the fire license, my lord. Kindly appreciate this. I am not a rank trespasser over here. Since 1970.
Trespasser is a civil dispute, which
Yes.
the civil court will decide.
Yes, they will. Well,
This is not for the writ court to
authority,
decide.
let the authority decide whether these documents or the issue that
My lord, the authority has
the fire license is a fake or not.
My lord, the authority has
the-
decided after giving a full hearing to both
minute.
parties.
No, my lord,
Minute.
certainly not. My lord, kindly see. 9th October. These
Show me this
9th
section
October, my lord.
35. Please show me section
Lordship,
35.
kindly grants me a second.
My license is the previous date of 18th December. That is my learned friend is, my lord.
Lordship, kindly peruse.
Yes. Director of the Superior Authority. Was an inspection conducted?
Lordship, inspection was conducted and a previous notice was there to cure the breach, which was not done, which is why this notice, and that is recorded on page 87 itself.
My lord, I used a chimney which up to the 3rd floor, up to the roof, the chimney is being, my lord, done through the outside.
Photographs?
There cannot be any generation of heat. There cannot be any pollution at all. My lord, kindly, my lord, adjudicate this.
Where is the hierarchy of the officers? This is issued by the Divisional Forest Officer, the DFO.
The divisional
And-
fire officer, Lordship.
Yes, fire officer. And here the authority mentioned in the section is director or the superior nominated authority. Do you have the hierarchy of the officials?
Lordship, this would be Lordship, kindly gives me a second, Lordship. I'll just take the
Anyway, corporation.
Well, our role is restricted to page 49.
49.
49, page 49. That is the representation dated, 23rd of August.
No, did you issue any license?
License is issued, by the UDMA department. Your lordship knows in other matters, there is a provision for
UDMA
issuing license
department.
by the
Yes.
UDMA online. We have the authority to cancel if it is obtained upon fraud. That will only be done upon inspection and verification. That part is pending. On
There is a representation, page 49.
page 49.
All right,
Written to the
I get it.
Commissioner, Viধানnagar Municipal Commission.
Pollution, you do not have anything. All right. And the
My lord, in case of the pollution control board, they had forwarded a complaint to the police. There also the police have not taken any action.
no, but then the learned counsel is unavailable.
Which is why, Lordship, I did not raise that issue, but that is also
Right.
there.
Who is the implementing authority? Is the police the implementing authority?
My lord, in this case, as I can see, Lordship, in the act itself, it is the nominated, there is a nominated authority who is supposed to take all these steps. As we understand, the divisional fire officer is the authority.
The director in the event of non-compliance. Section 36 comes in if 35 is not complied. This page 87 is only notice under section 35. May in the event of non-compliance take such steps as may be noted. Shall be taken as favor on demand by the owner of the notice within 30 days. All right. But then it is this page 87
Lordship.
can be implemented only upon issuance of a notice under section 36. Check up the
Lordship.
act.
Compliance with section 36 is the director may, in the event of non-compliance with any notice issued under section 35, take such steps as may be necessary for the compliance with such notice. Then
So
all
we are
expenses.
at this stage.
Lordship.
35 has
Lordship.
been
Lordship.
not complied with, so 36 steps
Lordship.
have to be
Lordship.
taken.
Lordship.
Let them take steps.
My lord, in the meantime, only
only one submission, my lord. My instruction
1 minute.
is that
In the meantime,
my lord, in the meantime, Lordship, I'm being subjected to harassment every single day. As I said, last night I was threatened by the police authorities. My lord, may some protection be given, because this is, we are dealing with a very, my lord, may I finish my submissions?
1 minute.
I've not
1
interrupted
minute.
my learned friend
I'm
whenever you spoke.
hearing him. Yes.
My lord, what has happened is, because the concerned person involved is very politically influential in the area, we are aged persons, we are extremely vulnerable at this juncture, which is why we were constrained to file this writ petition. And there are several. The fire issue is because there's this notice. I'm raising this today, but there are several other issues which we'll raise in due course.
my
And
instruction is that the authority who has issued this page 87 notice, he is not the authority for the particular zone. It is in the Bidhannagar Municipal Corporation area where the Rajarhat, well, the authorities under the Rajarhat, they are the authority to issue the fire license. And this notice under at page 87, this was issued by the, my lord, the this is my lord, kindly see the Ghospara Badamtola, they are the authorities, my lord, in my lord, Lake Town zone. My lord, kindly while adjudicating, my lord will be ensured that who is the actual authority. My lord, kindly see my lord, the
please come.
license. It says it is from the
My lord,
Rajarhat.
only for my lord's satisfaction, may I just show
This part, my lord, has to be looked into.
The
Because,
petitioner
my lord, kindly see towards
complains
bottom.
that the private respondent is running a sweetmeat shop and manufacturing sweets at the subject premises without any authority of law. Paragraph. Complaints were lodged before several authorities, including the police, the fire and emergency services, Bidhannagar Municipal Corporation, the Pollution Control Board, and who else? And also before the environmental engineer. Stop. The complaint of the petitioner was considered by the Fire and Emergency Services Department, and notice under section 35 of the West Bengal Fire Service Act, 1950 was issued upon the private respondent on 18th of December 2024. Step. By the said order, the private respondent has been directed to stop functioning the establishment, failing which legal action will be taken for violating section 11C and 12 of the West Bengal Fire Services Act, Service Act, 1950. Stop. The petitioner prays for. Now, the petitioner submits that despite the notice being issued, the private respondents are continuing with the functioning of the sweetmeat shop. Stop. Paragraph. It has been submitted that the petitioner and her husband both are ailing senior citizens, and the private respondent, being a politically influenced person,
This I am objecting,
threatening. The court is dictating. Please do not interrupt in the meantime. Is threatening the petitioners Stop. The police is also acting at the behest of the private respondent. Stop. It has been submitted that submitted prayer has been made to restrain the private respondent from operating the sweet meat shop. Stop. Learned advocate representing the private respondent. The Wakalatnama has been filed, isn't it?
Yes, madam, in the department, madam.
All right. Private respondent denies the allegation of the petitioner. Stop. It has been submitted that the sweet meat shop is in operation for years together. Stop. Licenses and permission from the competent authority have been obtained. Stop. The allegation of threatening the petitioner is also denied. Paragraph. Learned advocate representing the state respondents produces the instruction forwarded by the inspector in charge of Baguihati police station, signed on 5th of February 2025, which admits receiving the notice dated 18th of December 2024, issued under Section 35 of the West Bengal Fire Service Act. Stop. Next. The
same has also been served from the police station also, Pagadi police station, my lord. It's the second page, the second last paragraph, my lord. The last two lines.
The instruction also mentions receiving complaint from the petitioner on 27th of September 2024 and a general diary being lodged on 30th of September 2024, being Baguihati Police Station GDE number 2374 dated 30th of September 2024, over which an inquiry was conducted, but no substantive evidence could be traced to prove the allegation. Stop. Paragraph. Learned advocate representing the Bidhannagar Municipal Corporation submits upon instruction that a complaint is pending consideration at the end of the corporation. Stop. The license issuing authority is the Urban Development and Municipal Affairs Department. Stop. Next. An accommodation has been sought for on behalf of the learned advocate representing the Pollution Control Board. Stop. Paragraph. Upon hearing the parties, it appears that the notice under Section 35 of the Act was issued upon an inspection being conducted, and upon hearing the parties. Stop. Paragraph. Let the inspection report be placed before this court by the let the inspection report of the Pollution Control Board be placed before this court on the adjourned date. Stop. The when will Mr. Roy Mukherjee join? Next week. Achha. Let the matter appear in the list on 12th of February. Next Wednesday, I'm keeping it.
My lord, kindly record my document that I have got the license.
I'll hand it over. I'll return it to you.
My lord, may
I'm
copies
not
be
keen-
served to us, lordship.
It is a direct evidence I have placed in
I'll
the
check
directly
it
on the issue. My lord, kindly have recorded that I have placed it. I'm sorry.
Let the report of the Pollution Control Board inspection report to be placed before this court on 9 tarikh. Acha. In the meantime, the West Bengal Pollution Control Board and the police both shall ensure that the unit in question is run in accordance with the provisions of law. Stop. The police shall ensure that the petitioners are not harassed or threatened by the private respondent in any manner whatsoever. Stop. Next. In the event there is any breach of the legal provision, the necessary consequential steps shall be taken. Let the instruction of the police be written with the records. You take back all these things?
My lord, in that case, my lord, my document is there. My lord will not record it.
I have mentioned that you are carrying on business according to the permissions.
According to the permissions.
Then what?
My lord, two very short submissions, lordship.
Yes.
My lord,
Pendency of the writ petition will not stand in the way of the Fire and Emergency Services Department to take steps under Section 36 of the Act. Yes.
Two small submissions. One is, lordship, my affidavit of service. May I file it? Well, two small submissions. Lordship had asked about the authority of the officer.
Yes.
The hierarchy, lordship, that is defined in Section 2 LD of the Fire Act, which records the superior nominated authority means such officer not below the rank of divisional fire officer as may be nominated by the director, or such officer as may be nominated by the state.
The divisional
And
fire officer.
lordship. So therefore, that is taken care of. The other submission, lordship, these documents which were submitted by my learned friend, well, may copies be given to us. Otherwise,
I have returned it. The court has not retained copies, so it will not be given.
we'll.
And these are you can obtain under the
Lordship, we will do that. We shall do that, lordship. Lordship, any precedence may be given, lordship.
Urgent motion, it will appear.
Grateful, very grateful, lordship.
Yes, 3.
I am for the respondent from the.
And I am for the petitioner, my lord.
My lord, nothing survives in the writ petition, my lord.
My lord.
1 minute. You are for the respondent?
I am representing Hindustan Petroleum Corporation Limited. Respondent 226.
The main answer, me responded.
226. 226. Chance. All right. State is here. And West Bengal Tankers Association, you are there.
Nothing survives, my lord, in the.
Let me hear.
Very.
But main question in the writ petition is that, my lord, some person procuring the SC/ST certificate, forged SC procuring the documents, my lord, for which petitioners association raised complaint before the
State authority.
Tendering authority.
Why? What will the tendering authority do? Tendering authority is not the competent authority to decide whether a certificate is forged or true or correct. Nothing. It is a state authority. Did you approach the state authority?
My lord, just point out, is the question thereafter state authority. My kindly have to page, my lord, 73 once.
73. Yes.
Last paragraph.
Yes, STO. Right.
STO cancel one of them application rest of objection against 3.
All right.
One cancel, other rest 2 are not yet been considered, but nothing remaining pending.
All right.
My question is that this type of allegation.
Wait 1 minute. Let me know the person whose certificate has been cancelled. has been awarded the contract or what?
Not known to the petitioner, my lord.
It's not known.
No.
So what is your allegation that they are relying upon certificates which are fake?
Yes, ma'am.
They are not the competent authority to
Let the
decide.
competent authority be decide, my lord, inquiry about the matter. I just paying for inquiry, my lord. Kindly
Where
PRA,
is
my
your complaint before the authority?
My lord, page 48, my lord, through advocate letter, my lord.
Page 48. And over here, my client West Bengal Tankers Association. And against whom complaints were made? Where are the names and details of the persons against whom complaints have been made?
Lord, page number 32.
32.
32 and against Kumar Kalindi, he is one of the applicants, my lord. And again, page number 38A.
Oh, this you have made before the HPCL. HPCL is not the authority. And what can be done? You have approached the wrong authority.
And otherwise also it has become infraction.
And who are you? If he is the complainant, who are you?
I am the member of that association, my lord.
The association is not coming. One of the member is coming. What is it? What type of writ petition is this?
I am also one of the bidder. I also participated
Yes.
in the tender
So
process.
you are an unsuccessful bidder.
No, my lord.
What? No.
No, as per my instruction.
Have you succeeded in the bid tender process? No. What? Please come.
The letter of acceptance has also been awarded, my lord. If I may hand over, my lord.
No, no.
Not required. Otherwise,
The petitioner.
frivolous application, my lord. But petitioner success in the tender, my lord.
Petitioner succeeded in the tender.
But question
Letter
is-
of acceptance
Yes,
given.
ma'am. That's what I was trying to indicate at the threshold, my lord. There is nothing certain
What?
like success. Tender, my lord.
Oh, what is the allegation? No allegation.
Allegation regarding the SC/ST, my lord, certificate.
And that is a different cause of action. The tender, you are successful and you are.
They had raised complaint against some of the intending bidders, alleging that fake certificates have been relied on. Based on their allegations, they have been rejected. But after scrutiny, my lord, the petitions only have been awarded with the tender and the provisional letter of acceptance has been issued. Well, that is why at the threshold I was trying to impress upon your lordship, my lord, nothing certain.
And he doesn't know it.
It is not known.
What? Dismissal with costs? Because you've been awarded the bid, you'll be compensated from there.
Well, if I may hand over a copy of the letter of acceptance.
As a legal petitioner participated in the tender process floated by the Hindustan Petroleum Corporation Limited. Stop. On the apprehension that his bid may not be accepted and bids from was there any reservation?
Yes, ma'am. Yes.
Is this bid reserved for the SC/STs or something of that sort?
Page 21.
11, ma'am.
11.
ST quota per requirement 7.50% blood 11.
Oh,
Middle.
there was sentence ta shuru korun. There was a provision for reservation under the ST quota, scheduled tribe quota. Paragraph. On the apprehension that the authority may select bidders who possess fake and forged reservation certificate, caste certificates, objection was raised before the tender issuing authority. Stop. By the time the writ petition was filed and the same was taken up for consideration, the authority considered the objection filed by the petitioner and found the petitioner to be the successful bidder and issued the provisional letter of issued the has this been accepted?
Well, this is a provisional letter of acceptance.
Yes.
Thereafter, a formal contract is being executed.
No, but then did he sign this?
My instructions are it has perhaps been performed, my lord. We have issued this, my lord.
Achha, and a provisional letter of acceptance dated 20th of January 2025 has been issued in favor of the petitioner. In favor of the unit of the petitioner. Stop paragraph. As it appears that the petitioner has emerged as the successful bidder, accordingly, nothing survives to be decided in the instant writ petition. Stop. The writ petition stands dismissed as being infructuous. The provisional letter of acceptance dated 20th of January 2025 by Hindustan Petroleum Corporation Limited be written with the records.
Grateful, my lord.
কবেকার? একটা তো আবার একটা কি হলো? ও
Your Lordship,
For the state.
this is a matter where Your Lordship, the petitioner wants to avail the facilities under the Assistant Reproductive Technology Act.
তিনটেই তো করা হয়েছিল। ভুলটা কি একটাতেই হয়েছে? আমার যখন ভুল হয়েছে
The petitioner, Your Lordship, is the unfortunate lady who could not have a child even after marriage after more than 28 years because of various physical incapabilities. And now with the advent of this act under assisted reproductive technology, she wants to avail the benefit. Now the only reason for denial of this benefit is that the husband's age is above the criteria, threshold criteria. But the wife is.
What is the order passed by this bench, please show?
That is the judgment, Your Lordship judgment I am relying upon.
Even thereafter order has been passed.
So this judgment I could find. Yes, Your Lordship has passed two more orders. This is
last week also
passed by Your Lordship on 22nd of November 2020.
Yes.
Your Lordship, relying upon this because age is not a bar, and in the sense the extra benefit which I have in this case is that in the case where
last week an order was passed.
Yes, but that matter has been adjourned. Last week, that is not IVF, my lord. That is surrogacy.
No, IVF I have passed. Maybe you were not there. Somebody else was there.
Your Lordship has defined the term patient. It does not include any married couple. Any individual can also come and can avail the benefit because the wife is below 50 years.
Any submission?
Here, my lord, the age is in Shamolisha's case, my lord, the age is very marginal. That is just cross 55. Here, my lord, the age of the husband is nearly 60 plus.
62.
Wife is 46. Wife is 46.
The whole, my lord, the difference between Shamolisha's husband and here.
Your Lordship, the
two criteria is also important. Lordship has dealt with that also. The financial aspects and the, my lord,
that I have already stated or note that I am financially competent to take care of the child. And Your Lordship, the difference is that I am in a better footing because in this case, there has been a test of the oocytes count of the husband. It has been said to be more than what is required. It has high count.
But then will the husband be also required?
No, not required. Not required at all. No. I am just saying, since he has taken this point, This cannot be a bar. In my case, the husband has a better sperm count than in the case of the Shamuli Shah, which is reported.
Hey, Pradeep.
17, I have made statement.
In similar matters, so I'll allow this also.
Great.
I'll check up the order. Similar
Yes.
order can be passed. All right, disposed. Appearances, please.
Gratefully, Rashmi. Actually, the affidavit of service may be taken up. Thank you. On a 5, my lord, I beg to appear on behalf of the WBSC.
My lord, we are appearing on behalf of the petitioner, my lord. The writ petitioner is our fellow colleague and member of our association.
Yes, what has happened?
My lord, he has applied for a new domestic connection, my lord.
মনে হচ্ছে মানে very recently. very
Kindly have a look into last page. He applied for a new connection and he booked one flat. The agreement with the developers along with other documents he submitted. And now he is in the possession of that flat. But the electricity authority told until or unless you should not produce the ownership certificate documents.
He has given a notarized agreement for sale. No proper document of ownership and possession is given, my lord.
My lord, the notice was issued to
Sir,
my
he has
address.
applied to that as that we have sent it in that address, my lord. Let him intimate the present condition, my lord, because this notice we have sent on
page
10th
35,
of
my lord,
December.
kindly have a look into.
There is no improvement after 10th.
My lord, he has to give the deed of conveyance. My lord, this is a notarized
Why, my
agreement
lord,
for
even
sale.
the trespassers is also
But
entitled
whether
to
he is
pay
in
the
possession or not, we don't know.
Yes.
Go and cause an inspection and
Yes,
see.
yes.
Right. Whether it is feasible. How many other flat owners are over
Lord,
there?
there are 50 flat owners. my lord.
50.
50. And in
And
a
they are
complex.
getting electricity.
Yes.
No, my instruction is no. All of them are not
No,
applied. All of
all
them.
may not have applied, but is there any connection over there?
That
Is there
I have-
any feasibility of
That
providing
because the
connection?
promoter has taken the connection because the building is still in,
Lord, there is
Under
meter board.
construction.
There is meter board position.
No, it
and
has
my
to
lord,
be there has to be a meter
Lord,
board
the
position,
connection
otherwise
given in the name of the developer.
But difficulty is possessing a property or a flat which does not have a completion certificate is illegal. A member of the legal fraternity going and doing something illegal, take care of this also.
My lord.
Until and unless the CC is given, my lord.
I understand. So keep this in mind. Till a CC is granted, you are not legally entitled to take possession. Now, I know that CC is not granted all the time. There are deviations. There are many reasons for which the CC is not issued. In that case, if court passes order, go and grant electricity, then it will create a very bad precedent. Let them go and see what is there and let them come back. Please come.
Lord, kindly direct.
The petitioner seeks new electricity connection. Where is the premises number? At Heaven Gateway.
My lord.
What
My
is
lord, 3463
3463?
Tegoria, Sonar, page 35.
Yes, 3463 Teghoria, Sonarpur, pin number such and such, page 35.
My lord.
Right? Is there any flat number or anything of that sort?
My lord, flat number 1A.
Where do I get that?
We will inspect the whole premises and give a report, my lord. We'll inspect the whole premises.
But where does he want? Let me write it first.
My lord, that you will get it. My lord will get it from the schedule of the. That is page 23. My lord will kindly peruse. Internal page 6. Second line, my lord. Flat number 1A on the first floor of
Acha.
the southern side.
At flat number 1A, first floor, southern side of Heaven Gateway বলে যেটা আছে সেটা পেজ 35 এ ঠিক আছে স্টপ
Lord, one indulgence, my lord. They issued quotation and the quotation amount had already been paid.
I am not denying that.
all right the petitioner has deposited the amount quoted by WBSEDCL for providing new connection at the subject premises. Stop. According to the authority, there are certain discrepancies in the application made by the petitioner. Stop paragraph. The authority is directed to conduct a spot inspection upon notice to the petitioner and any other necessary party to ascertain the feasibility of providing electricity connection at the place mentioned by the petitioner in his application. Stop. Let the inspection report be placed before this court on the adjourned date. How long?
I'll give me fortnight's time.
Fortnight's time. আচ্ছা ঠিক আছে list on 26th of February.
I'm grateful.
26th of February.
Under the heading urgent motion.
Lord, the affidavit of service be kept on.
Yes, service is taken on record.
Lord, 6 and 7 বলুন আপনারা
6 and 7. We are for the respondent. You never feel good.
From the learned advocate general state, my learned senior Mr. Bhattacharya, that he has some personal difficulty and accordingly Mr. Bhattacharya left the court.
So
Mr.
you want
Advocate General
urgent-
has certain difficulty today.
So what you want? You are for the
Well,
petitioner.
tomorrow,
Who are you? You are for the petitioner.
petitioner. Friday, day after tomorrow, my lord.
Same heading, same heading.
It was adjourned on the last day. Now today also.
But today,
there is an
this is not
adjournment.
on our part. It is their difficulty. They are not saying this.
But,
They should have said.
but I
prior
have
to
been
me.
instructed that Mr. Partho Sharuti Sengupta is appearing as the leading
Petitioner.
counsel in for one of the petitioners, but he has felt certain discomfort and left court.
Today?
So he had a word with my senior in the matter, Mr. Abhutosh Mujumdar, and that he would possibly want to do it on Friday. This is what I have
Friday.
been told. I do not know about the conversation which my learned senior friend had, but
Very
this
well.
is insofar as my matter is item 6 is
But I
concerned.
am appearing for the Union of India. You are not. Well, these are practically public interest litigation. This should be.
So on merits, I do
That
not know
should
what
be
the matter
decided
is
on
about. I do not know what the matter is about.
Yes, it has not been
আচ্ছা
taken up.
প্রদীপ এখানে লেখা আছে by consent February 5 same by consent
My lord, under the same heading, my lord.
Friday হচ্ছে 7 তারিখ 7th.
Grateful to your lord. Grateful.
6 and 7 and ongoing.
Same 6 and 7 is same.
6, 7 similar matters.
6 and 7.
My lord, item number 8, my lord. I am appearing for the petitioner, my lord.
জানাবাবু 8 and 9 ডাকবেন আর ডাকবেন না
My lord, item number 8, my lord. I am appearing for the petitioner, my lord. It is that matter, my lord, being tortured by the son and my lord, daughter-in-law, my lord. I approach before your lordship, my lord, before this honorable court, my lord. Matter was taken up several occasions. First, my lord, your lordship was pleased to direct the son to file affidavit when they will be vacated the house. And last order was that, my lord, your lordship was pleased to take, my lord, direct the parties to take instruction from their respective clients, my lord. My lord, so far my instruction is concerned, my lord, I had a talk with my client. My lord, I requested him kindly give some accommodation. He, my lord, informed me that his son called him in upstairs and in a higher tone ordered him, please come to me if you want to talk with me. My lord, father is present, my lord. And my lord, Secondly, my lord, so far business is concerned, today morning in my bar association, I had a talk with father. Father told me that, my lord, son is not in a position to leave my business. He told my worker, please threat my father. And the worker threatened my father by saying this, you have to leave the business upon your son, otherwise I will kill you. My lord, this is the situation. Father is present, my lord. I do not want to take any risks, my lord. If your lordship wants to ask something, my lord, father can address your lordship, my lord.
I can place out, my lord, father is beating the wife.
Father is?
Beating out the wife. There is a video record on it.
Your, that means the daughter-in-law.
Daughter-in-law.
Father-in-law is physically troubling.
I didn't
It
open
is a very good ground for the daughter-in-law to move out. Don't stay. Don't stay with such a cruel, inhuman father-in-law.
What I respectfully submit, considering, my lord, I have 2 children. Why not?
I don't think the court will be able to help you out.
My lord, I will move out from my business.
Yes.
I have taken.
No, not only the business, the house also.
My lord, kindly, I don't, my lord, then I have to go to the streets.
No, no.
But
You can find another accommodation.
My lord, accommodation, no business, nothing, my lord. I just require, my lord, 6 months time.
Listen, if this is the conduct of the son and the daughter-in-law, then they should not stay together.
I don't make any.
A very unhealthy atmosphere is prevailing. The children of your client will not learn anything. They will see only all these things, the negativities in life. You cannot teach these things to the young ones, right? So they will see their father being cruel or acting in this type of manner with his father. What will the children learn? So it is better they move out in a healthy atmosphere, let the children grow up. It's no requirement of staying together.
One room, my lord, business, I will leave.
No. Every day this nuisance will continue. And Mr. Ganguly's client will not be in a position to help either of the two. I think you should move out. There is no other option. What do you say?
No source of income.
What can your client do? Nothing.
When the record, my lord, then we have already asked the father to come up with a complaint. He's saying this is a futuristic complaint, not right now. They have to sort it on their own. We cannot. It's a very difficult task for us.
At this stage, my lord, if it is, my lord, it will be too harsh, my lord. I have no.
No, not too harsh.
My lord, I will.
And especially if the son is seeing that his father is adamant with him, he should take a softer stand. But see what the father is complaining of. What can be done?
I don't make any complaint, my lord.
And you have also mentioned that the father-in-law is physically abusing the.
I have mentioned the incident, but I have not made any complaint against it. I have not made any complaint.
You have not made a complaint, but you have mentioned that this is happening. Why will they tolerate this?
It can be, the house can be separated, my lord.
It is his house. Whether he will separate it or not, will the court direct?
That I can understand, my lord. But
the court cannot. Neither you, because it is not your house.
Kindly visualize my condition.
I
2 daughters.
Nothing doing. You have to shift out.
Business, I will definitely shift it out. But I require around 6 months time.
And if 6 months, when was the order passed? You came up with a recalling.
I came up with
the order was passed.
Initial order was passed on.
My lord, on 5th July 2024.
Right, 5th of July 2024. And now we are in the early date of February. 6 months have passed.
Investments and loan is there, my lord. Kindly give me 6 months, my lord. I will definitely file an undertaking and
No. 6 months undertaking. It can never be compliant. In the meantime, you see the father is has gone up. Nothing doing. Very adamant son and father both.
Two children, my lord, schooling is also there, my lord.
Body language says all. Nothing doing. I am
kindly
sorry.
consider my two daughters, my lord,
No,
young
no.
daughters.
A father with two minor daughters behaving in this manner with his father is not acceptable. Not acceptable.
I will be out of, my lord,
You
without
will be
house,
out.
without,
If
my
this
lord,
is what you have done, you have to suffer the consequences. What can be done?
without house, my lord, without,
Let him make his own house.
my lord,
Why will he depend upon his father, an able-bodied person?
my lord, a business has been started. My lord, kindly.
Let him start his fresh. All so many startups are coming up. Let him also take. Let him take a leap. He will learn how to swim.
Kindly give.
Till you throw him out in the pond, he'll not learn how to swim. Let him go. Let him find his own business.
Kindly give me some time.
No, sir. How long? From July till we are in the first week of February.
To shift the business investments are there, my lord. Kindly give me another 5 months time.
No, no, no. Sorry, sorry. I'm very sorry.
Undertaking, my lord. 5 months from today, my lord, my lord, submit before because I will make an affidavit to that effect. 5 months time, my lord. Kindly, I humbly state, my lord. 5 months time. By that I will shift. 5 months, my lord. That, my lord, I humbly pray, my lord. Only 5 months, my lord. From today, my lord, 5 months, my lord, I will make my all arrangement. Arrangement also will take some time, my lord.
Where does his father's? How big is the house?
My lord, it is two storage building, 4 rooms are there, my lord.
Two storied.
Two storage building, 4 rooms are there, but one entrance is there, my lord. My lord, it is like a garden house. It is a big.
Whatever. So 2 rooms in the first floor and 2 in the ground floor. 4 rooms.
4 rooms.
First floor 2, ground floor 2. Where does the father stay? Top.
The father stays in the ground floor, my lord. So far, my understanding is concerned, my lord. Most humbly, I am praying before your lordship. He said, my lord, that it is not possible to give the son to give any type of accommodation because, my lord, all are open, my lord. It is not like, my lord, flat house. It is all are open. It is like a baganbadi. It is all are open, my lord. There are 2 entrances. Every, my lord, in every way there are entrance and exit are there and entrance are there. So it is not possible to separate themselves from his son, my lord. I have a detail, I have a top, my lord.
See, today you cannot throw him out.
My lord, I am living up to your lordship, my lord. I am not submitting before your lordship. It is my house.
Listen,
I will take steps. I am not on that, my lord.
Try to understand and try to visualize the practicality of the whole thing. Today you cannot throw him out. You have to give him some time to move out, right? In the meantime, what do you propose? Every day you go and fight, or you stay separate in such a manner so that the two don't come together?
Lord, may I submit one thing? My
Yes,
advocate
please.
on record visited their place. My lord, his son, my lord, told my advocate on record he is not present today. Engachi bengachi lawyer onek dekhechi ami bujhe nebu. This is the language, my lord. My junior, my lord, informed me, my lord. My junior informed me, my lord. Sir, kindly submit before the honorable court. This is the language of son, my lord. This is the language of
I have
son.
not made
Because,
any
my lord,
allegation
he is a
against my
professional
father. Neither I have
my
made
lord.
any allegation
My
against
lord,
him.
advocate was
What I am
addressed in
saying,
no
my lord, is
in this
basic
way.
right to life of my two daughters. But this type of allegations, my lord, I raise strong objections.
But then you say that the father-in-law is physically abusing the daughter-in-law. Why stay there? This is I cannot understand. Why stay there? Why don't you move? You have your own self-respect.
No source of income.
No source of income.
Other than my business. Business requires some time. And my lord, no house also. At this young age, my lord.
Young?
My lord, I have invested a huge
The
amount.
definition of young will change. Since the client is present in court, I can see how young he is.
Kindly visualize, my lord. I have
No,
two
I can visualize everything, and by visualizing, I'm trying to understand how can he be young at this age? He's got 2 children. And he should know that it is he who has to support his family, his wife and children. He should not depend upon his father's income, his father's business to maintain his wife and his daughters.
Yes, that
This is not done.
That I bow down.
Then?
That I bow down.
So, what he is doing is not proper. It's absolutely illegal on his part to do this. And if he has got his mindset that he'll look after his father's business and earn money and he'll run his family, then he is in the wrong track. Please advise him. how to behave himself with his parents. This is the father is absolutely unwilling. It is his house.
My lord, I bow down.
Then what is your suggestion? What do you propose?
Kindly give some time.
What in the meantime, what will you do?
My lord, I will not have any word with my father. I'll not have any word with him. I'll not, my lord, make an undertaking. I will not.
Where do you stay right now? In the first floor or the ground floor?
One room in the first floor. Right?
One room in the first floor. And in the other room, who stays?
Lock and key.
Lock and key. And the father stays in the ground floor?
The ground floor. And ground floor, my lord, there is one space. My lord, I just run the business. I'll shift.
Shift immediately. His business he will not run. It is his business and it is his business.
Kindly give some time, my lord. I will definitely.
Immediate shifting.
Immediate shifting, my lord.
The business. And for staying.
I have to take a rent also of another place, my lord. That will also take some time and shift.
No, these proceedings are pending for so many days. What were you thinking of? That the court is going to leave it?
No, Lord, absolutely.
You've tried your best to get the matter taken out from this bench to some other bench. Now, for whatever reason, it has been assigned.
Because it just normally just determination change, my lord.
Whatever. Now it has come over here. And you do not have an option. I have made my mind clear. What do you do?
Kindly give some time. Kindly give some time, my lord. My client is physically present, my lord. Upon his instruction, my lord, kindly record. He has given me oral instruction. I'll come up with an affidavit. My lord, 5 months around, my lord, definitely I'll shift my business. Because I have to take my lord, kindly visualize, I have to take one room for my business. Agreements are there. My lord, some equipments are there which requires to be shifted.
Now this is going to create further problems because you say it will be your equipment. The father will say it is his equipment. So these things will remain. Now see what the writ court is being transformed to. This is a writ court. It is only where the points of law are being decided. And now the court is going to decide who is going to take which equipment and what to do with this. It is only the right to life that the court is protecting, nothing more.
Only for that, my lord, I am.
Otherwise, this court does not have any jurisdiction to enter into all these familial issues. Right to life is involved over here. So, what about your sometime means when?
As per instruction, my lord, 5 months, my lord, I leave it on your lordship. As per.
To shift the house.
No, business. Because some, my lord, accommodation is also required. Some accommodation to run the business. I have to take one, my lord, place where my business will run, a accommodative place from where the business, my lord, I can run. That, my lord, rent I have to take from another area. So, my lord, I have to talk and negotiate. My lord, will take some time. Within one night, my lord, I will come up with an affidavit to that effect that I will shift within this time. My lord, it will be an undertaking before this. My lord, if I make an undertaking on an affidavit, my lord, absolutely contempt is also maintained. So, my lord, sometime in the meantime, my lord, I will talk and negotiate with the persons, those who give rent of business places. And that business place, my lord, kindly visualize, must be in a good position so that I can run my business. I humbly pray, my lord, just considering my 2 children. My lord, I don't have any other source of income. If this goes, my lord, everything goes. And one room for the time being, my lord, I will not make any disturbance with my father. This much undertaking, my lord, I will definitely. But that is why, my lord, I have come up with a recalling application, my lord, stating all the facts. And I have not made any allegation against my father, against my mother, anyone.
No, you've made oral submission. You may not have made written statements, but then you've made it clear to the court that this is the relationship between the father-in-law and the daughter-in-law.
I humbly request, my lord, don't take it as my submission. Since my learned friend, my lord, stated, my lord, I just informed the court.
No, it's no use keeping it to yourself. You've made it known to the court that this is what the picture is. And the court is aware how this strained relationship between the parties is. And it is for the benefit of.
My lord, informed my client. I told him to talk with their parents.
Whatever. Now your personal initiative is not helping. Right, so what can be done? The court has to be strict.
Lord, I bow down, my lord. I leave it on your lordship, but kindly, my lord, considering my two daughters, kindly give me some time. I humbly pray. Otherwise, my lord, two daughters, they are educated.
For saving your place over there, you are projecting your minor daughters.
My lord, I am not, but still, my lord, since I don't have any other source of income, just to shift today, if your lordship direct me to shift my business as of today, Lord, today I will not get any other place.
And I can see the complications that are going to come up. You can also visualize, and I know Mr. Chaudhary can also visualize.
I am there, my lord. I will come up with an affidavit to that effect. In the meantime, my lord, I will talk with the persons, those who give rent, my lord, I will go there. Because, my lord, immediately if your lordships direct, my lord, kindly visualize the scenario. My wife, my lord, both of them are party in this matter.
How are you earning your living? Because this is your father's business.
Only from the business. Only
This is your father's business.
Absolutely, my lord.
You are there as a caretaker.
My lord, kindly, my lord, I respect.
What is your role in the business?
My lord, I respectfully submit, my lord. This business has been run for more than 10-15 years. I was working with my father only, with his consent. Now he has become old. So I was continuing, my lord. It is not a fact that I have suddenly come in and grabbed the business.
No, it is all right.
It is a fact, my lord, for the 10-15 years. Around 15 years, my lord, I was doing my business with my father. Now disputes have cropped up now. Disputes have cropped up now. Whatever may be the reason, whatever may be the behind reason, my lord, maybe my sister, or I don't go into all those things. All what I, my lord, respectfully submit,
My lord, he is entering in every matter and submitting that I will not enter. My lord, it is not the
No, my lord,
procedure.
Wait.
My lord, I have just now taken instruction, my lord, he is
Will the father be in a position to run the business without his son?
Yes, my lord. My lord, just now I have taken instruction 2 days back, my lord. He went to his own business place. His son told him, don't enter into this room, go before the court.
Again, my
This is, my lord, this is the attitude, my lord. My lord, in this attitude, my lord, this problem cannot be solved. And just now he told me, my lord.
Very well, if this cannot be solved, I'll release it. You go before the civil court, get it settled.
Most humbly, I am praying before your lordship, my lord. Kindly, my lord, give the protection of my life, my lord. Because I am not in a position to live there.
Right.
Day to day,
So what is to be done? You engage your security guards for your protection? What do you propose?
If it is fallen from your lordship, my lord.
Right.
My lord, then, my lord, I have nothing to do, my lord. You will be on road. And if your lordship, my lord, gives protection, my lord, we will be protected. That is up to your lordship. For this reason, my lord,
But the court is trying to. The court is trying to resolve the issue.
Kindly resolve,
Right.
my lord, my lord, I
But
am
you should come up with some plausible solution.
I need to pay monthly maintenance from my business to my father.
My lord, it is not at all.
It is his business.
My lord, he is not complying your lordship last occasion's order. Your lordship last occasion, my lord, please to direct, my lord, kindly see, my lord. Last occasion, your lordship was pleased to direct, my lord, point number 6. As the parents have disclosed the specific stance before this court that they are not willing to allow the son to run or took out a business in this manner. Accordingly, the son has to find out the alternative accommodation to shift his business.
Just need some time.
This order has not been complied also, my lord.
No, he's finding out a place where to shift.
Practically, he is doing everything on my business, and he is, my lord, I have no access over my business. I have no access. My lord, I went there, my lord, I have heard that kindly go, my lord. This is the situation, my lord. How can I describe, my lord?
15 years the business has been run, I along with my father. Admittedly, it is my father's business. My lord, I don't say that it is.
A regular basis threatening is going on and others are going on. I have stated details in my
where from does the funds generate? Where from does the funds generate?
From my father, from my business.
Initially from my father, I don't deny, dispute this fact. Subsequently, my lord, the business has been run. I have also generated. It is not the fact that totally my father has, definitely my father has invested. I have run the business. He is old. He has not taken care of the business for few years. It is not that. Initially, I was with, it is absolutely with consent of my father. Suddenly, my lord, I have not come into the business. trespassers, as a trespasser, I have not come into. It was my.
No, this you have mentioned already. But thing is, if the father doesn't want, since the business is his and the father doesn't want it, so.
My lord, what I say, my lord, kindly give me 5 months time, my lord. In the meantime, definitely I will shift. I will come up with an affidavit to that effect. Till now, my lord, I have not.
The time that you are seeking is only for you to stay over there. But this business, he has to stop it immediately.
Absolutely, my lord, I have to stop the business from today.
Obviously,
Yes, my lord,
because
that
this
order
is
is
what
there,
is
my lord.
happening.
Your lordship's order
This
is
is
there.
what is happening.
Stopping the business today would be, my lord. My lord, kindly give some time, my lord. I leave it on your lordship, but labors and all, my lord, many.
Labors are father's labors.
Yes, my lord. My lord, he is saying he is quite capable to, my lord, to run the business, my lord. He is quite capable, my lord. He is not in a position to enter into his
What
business.
does your son-in-law do? What does your son-in-law do?
Allah, he is the officer personnel of Mahindra and Mahindra company, my lord.
So he is.
No, he stays in. He stays at Dom, my lord. No nexus, my lord. No nexus.
For my information, he is not the officer. He works.
Well, he's service. He's a serviceman. He works elsewhere. He works elsewhere, right? So from tomorrow, if you are to stop, what will you do?
Kindly give some time. It will be.
You'll go and bang heads every day. This thing will happen. Every day it will happen.
Come up, my lord. I will give me some time. I'll come up with an affidavit, my lord. I will definitely shift.
No, what does the shifting mean? Shifting means you have to move out. Otherwise, you cannot run your business. They are your clients.
My lord, kindly visualize one thing. I have to take one room for accommodation to run my business.
Room for what? Accommodation of what?
Well, the business place.
Business place.
At least in a
That is absolutely separate. You take a room, you do your business. You cannot take anything from there to that new place.
Just my lord, I will not take any machine or equipment. Only with the workers, my lord, I will shift.
You want the workers to go with you?
The workers, my lord, according to my instruction, my lord, they have been appointed by me.
All right.
Appointed by me.
So they are.
He is saying that it is his worker, my lord.
I can foresee.
Workers, my lord, what I propose, my lord, they will decide where they will go.
Yes, yes,
But
very well. So the son will stop because he is not there. Any fund that will be generated, father will say it's my fund, son will say it's my fund. The worker, you've started quarreling with the workers also now. So this is going to continue. You
give me some time, my lord, I will shift.
Very well. You file your affidavit. A 1 week time I'll give you. Make up your mind. File your affidavit within which time you will shift out from the house.
Just specify or whatever, my lord, I submit, my lord, may I just specify some time?
What? Specify?
Some time. Some time.
In the affidavit, you will specify the time. In the affidavit that you will file, you specify within which time you will move out. It is for you to disclose. I will post the matter next week.
No, my lord, I just want to make it. My lord, I am just in presence of my learned senior friend, my lord.
Take your time. There is no hurry because it will be on affidavit and your client will be bound by that affidavit. And making false submission before the court, make him know the consequences.
Initially, I proposed that.
Yes. So your proposal, don't keep it to you. Today you are there. Tomorrow someone else will come.
This, my lord, subject to kind correction of your lordship, it is not the question of shifting. It is the question of leaving the business. Because there is no question of shifting. It is the question of leaving.
He will leave the business.
Yes, ma'am.
He will leave the business.
I'm grateful, my lord. It is the question of leaving.
And he will move out of the house.
Constantly, my lord, submissions
But
are coming
then,
that, my lord.
But then he requires some time.
My lord. My lord.
Right? Only for the protection of those two minor daughters, the court is giving so much of time to you all. Otherwise, more than 30 minutes in this matter is not this.
They will
Ashwin,
business will
please
be
come.
shifting. There is no question for shifting. Question of leaving, my lord.
Heard the
Kindly
parties in
record
details.
this in this way, my lord.
Stop. Paragraph. It appears that there is regular fights and quarrel between the petitioners and their son and daughter-in-law, who are the private respondents. Stop. The petitioners are concerned about their life, safety and security. Stop. Paragraph. The petitioner number 1 and the private respondent numbers 9 are personally present in court. Stop. Paragraph. Now, it appears that the parties are not in any mood to adjust with each other. Stop. Both parties have got innumerable complaints against the other. Stop. Paragraph. As the building, as the residential building of the parties belongs to the petitioner number 1, and the petitioner number 1 for his own safety and security does not intend to allow his son and his family to reside over there. Accordingly, the private respondents ought to move out from the said place. Stop. The business from where the earning is generated belongs to the father. Stop. The son helped the father in running the business for quite some time. Stop. The father intends to, the father right now, does not want any help or assistance from his son because of his behavior. Stop. The father, through his learned counsel, discloses before the court that he is in a position to run the business independently without the assistance of his son. Stop. Paragraph. In such a situation, the son has to immediately stop the business which he was carrying on with his father at the same place which belongs to his father. Stop. Paragraph. Learned advocate representing the private respondents seeks some time to move out of the house and to find out a place for starting a new business. Time. Achha. The matter stands adjourned till 19th of February.
18th, 19th, I have some personal. That week, my lord, I have some personal.
Then my lord, 17th, my lord.
No, 17th.
17th. 14th of February.
14th of my lord.
14th February. The private respondents are directed to file an undertaking by way of an affidavit disclosing the time by which the private respondents will move out of the residential house. Stop. Next. The private
the
response.
business, my lord.
That's a residential house and the business. ঠিক আছে? আচ্ছা।
And in the meantime, my lord, may I pray for one indulgence, my lord? Police
The-
protection is required, my lord.
The
Most humbly, my lord, kindly consider.
private respondents are restrained from interfering with any activity of the petitioners and not to create any breach of peace at the subject place. Stop. Next. Which police station is it? Domjur. The officer in charge, Domjur Police Station, is directed to keep strict vigil over the area, over the property, to ensure that there is no breach of peace and the life and property of the petitioner is not endangered in any manner whatsoever at the instance of the private respondents or their men and agents. ঠিক আছে? List on the 14th.
I'm grateful, my lord. Deeply
The
obliged.
order that I have to leave it immediately.
I give you time till you file the undertaking.
Till I file the undertaking.
So
Requires some time.
till 14th, you are safe, but then
Immediately after 14th, I have to leave. My lord, that
more or less
not be
find out a place.
too harsh, my lord. Immediately on
I cannot help if this is the behavior of the father and the son and the son and the father, then nothing can be done.
With my lady's permission, may I just mention item 45? I've come specially from Delhi for this matter.
Yes.
It was listed on 31st. The senior advocate Jishnu Saha had mentioned, and my lady indicated that it would be heard today. My lady,
Yes.
there's an impediment in this matter because my limitation to file a commercial suit will expire on 23rd February. If my lady recalls on the order in the order dated 15 January.
Very well. Item number 45. Item number 45 listed tomorrow morning.
My lady, at this fixed time, or should we mention in the morning?
No, don't mention. Was it heard earlier?
It was heard on 15th of January for the first time, my lady. It was.
And what was the order passed?
My lady had directly adjourned it for final arguments. My lady directed the parties to be present for final arguments on the next date.
Is there any point of law involved?
Yes, my lady. The respondent, my lady. So this was a commercial contract which was entered into in the year 2011. My lady, we constructed everything, and thereafter, my lady, before the date of signing of contract, and after I was so between the date of declaration of me as the L1 bidder and the date of signing, the government of West Bengal issued a gazette notification omitting the arbitration clause. We have challenged that gazette notification because the petitioners, we want to go into arbitration because of the 5 extension of time which was granted to us.
Y'all want to go into arbitration?
We want to go into arbitration. My lady has we had argued on 15th of January, if my lady recalls that order as well. My senior had argued that day, my lady. We only want to.
Yeah, so there is no in-house resolution dispute mechanism.
My lady, it is only arbitration as per the contract.
It was there.
It was there. It was in the contract. It was omitted unilaterally by way of
All
a
right.
gazette notification. There are judgments of the Supreme Court on which we will rely.
So it is more or less a point of law that is to be decided,
It is
right?
a point of law, my lady.
All right. Tomorrow at the top of the urgent motion, please put this. Adjourned motion top.
Obliged, my lady.
With regard to item number 10 to the exotic bird matters, your lordship had said, my lord. So Mojumdar is also here, my lord. My lord, I had informed Ms. Pandey as well, my lord. She's there online.
Similar from the corrected version to the proposed correction to my learned friends. As far as
It is 9, is it 9? No, it's 10.
10
to 16. 9
Wherein your lordship had passed an order and they want to add a certain portion they are proposing for Correction in the order.
9 is anybody there? I'll take it up tomorrow. I'm here since morning. 3:30 is already over. Then also the court is not being relieved. 10 to 16. देखिए order tag to.
Only this sentence, if your lordship kindly considers to be incorporated. I have shown it to my learned friend.
Yes, this sentence, it was mentioned on the last day. Right, this can be added.
Your ওটাই নাম্বার এটাতেও আছে আরেকটা দুটোই লেখো মামলার নাম্বার গুলো
Paragraph number 10 possibly will not be required to be there. Copy of the writ petition has been served upon all the authorities and their replaced copy may be forwarded to the as non-registration. I'll add up this line. And are all the respondents represented?
Yes.
Then
your ladyship, if I may only indicate, the order which is before your ladyship, which was passed in my matter, along with another matter which your ladyship has also passed the same orders.
Yes.
As far as the respondents in those matters are concerned, they are over here.
Yes.
Ms. Pandey was there in one, another one. She's also here. They have consent. They don't have any objection to that. But if that can also be treated on days list because they are not in the list today.
Which matter?
This matter.
2125 has been disposed of.
Yes, 2127 and 1717. These are the two matters which were disposed of. I had, your ladyship will kindly recollect, I had also mentioned on the last occasion that this sentence needs to be added because the idea was that these matters.
So 3 matters. This and the other 2.
This and another one.
Another one.
And along with 10 to 16, which are.
No, 10 to 16 is there in the days list.
Apart from that
can be done. If you want this order to be
yes.
A list will be published as to be mentioned, it can be done. That is separate.
Yes.
That is separate.
Yes.
But today we are on 10 to 16.
Yes.
All right.
Yes.
Your matter I'll take care. Acha. 10 the petitioner is here.
Yes.
And the respondent is here.
Yes, respondent is here.
Please.
Your lordship, I am not appearing in 10 to 16 matters. My matter was disposed of, your lordship. Which we are asking for correction.
The last location to ensure somebody.
No, somebody should not appearing.
Your lordship
appearing. Appearing. Are you aware, Ms. Pandey?
Your lordship, I cannot. It has to be from Ministry of Law and Justice. Your lordship, if so directs, a notice could be given to me by a court's order. But otherwise, I cannot accept.
Ms.
No, this is another
my
problem.
matters only.
Yes. What about the service upon
the
yes.
Lordship, I am appearing for the Lordship, I am appearing for the respondent numbers 2, 3, and 4 in item number 10, your lordship.
No, that is the state respondents. Then in the absence of the respondents, it will be difficult. You ensure presence. Inquire from the office who has been engaged. And please come, then I'll pass orders tomorrow.
I said on the last occasion is that, if you are not protected for the time being.
I can understand. But without the other side, how can the protection be given to you? It will become difficult.
Ms. Pandey, she said that she would appear in these matters.
No, she has not been engaged. আচ্ছা একটা কাজ করুন তো এনার মামলা দুটোর নাম্বারটা দিন কালকে এটাকে টু বি মেনশনে রেখে দেবেন তো
May I supply the two post titles along with the numbers? These are the ones.
Your lordship, the learned DSG is here. He can take note, appear for all the respondents. If
where is
your lordship, he has joined.
join করেছে
If your lordship passes an order, he can appear here.
No, not in that manner. Then a line has to be recorded.
Your lordship.
But if Mr. Trivedi says that he is appearing, then it is all right. Well, tomorrow, please tell him to come.
All these